Good evening, everybody. A very good evening to all of you. Just let me know quickly if I'm properly visible and audible so that we can start our today's revision. Let me quickly share the link of the class in all the groups so that everybody can join. Good evening, Jethalal. Who is Jethalal? Good evening, Kushi. Good evening, Arya. Good evening, Palak. Good evening, Aman. Good evening, Pavan. Okay. Good evening, Kushi. Good evening, Mehboobi. Okay, great. So let's start our today's revision. And as you all know that today we are going to continue with our general meeting. So just a minute. Great. Great. So let's continue with our general meeting. In the last lecture of the general meeting, we started section 96, 97, 98, 99, 100. 96 was for general meeting, 100 was for EOGM, 96 was for AGM, 100 was for EOGM. After that, we studied 101, notice, Shagun ka lifafa. After that, we studied 102, that is explanatory statement, and after that we studied 103, which is notice. So yesterday we studied this section 96 till section 196 to 103. So today we are going to continue from section number 104, right? So as you can see this is your bare act, and we started with 96 annual general meeting. We are done till 103, which is quorum. Now we have to continue with section 104, which is chairman. Good evening, Shikha, Ankush. Great. Okay, 103 was left, 103 wasn't done. We were done till 102, 101 notice and 102 explanatory statement. So today we have to do section 103. So let's start with section 103, which is basically a good section, interesting section plus an important section. Basically this whole chapter is important because this is your part B. So be very attentive. We are going to revise our section 103, which talks about quorum. What do you mean by quorum? Quorum means the minimum number of members who are required to be present at the meeting in order to validly transact a meeting. So quorum means, let's say our class quorum is minimum 5, which means that when minimum 5 students will come, then only I will start the class. Otherwise, I will not take the class. So that is quorum. Minimum this much member will be present, then only meeting will be conducted. Otherwise, meeting will not be conducted. Is there any specific quorum in the Companies Act? Yes. Companies Act has specified a specific quorum for general meeting, and which is discussed in section 103. Section 103 says that quorum is different for a private company and a public company. If your company is a private company, then quorum will be 2 members personally present, which means for a private company the quorum is 2 members personally present. What do you mean by personally present? Personally present means you should yourself be present at the meeting. You should take your body and you should be present at the meeting. You cannot send somebody else in place of you. You can send somebody in place of you, but that person will not be counted for quorum. So basically, if you are sending somebody else in place of you, that person will be known as proxy, and proxy is not counted for quorum. So that is why for quorum at least 2 members should be personally present. In case of private company, then only meeting will be held. In case of public company, we will see there are total how many number of members in case of public company, because in case of public company there can be unlimited members. So if the total number of member is up to 1000, then the quorum is 5 members personally present. And if the total number of member is more than 1000 but up to 5000, then the quorum will be 15 members personally present. And if the total number of member is more than 5000, then the quorum will be 30 member personally present. How to remember this? Just remember 5, then into 2, that is 10, and then 10, sorry, yes, sorry, 5 plus 10, that is 15, and then 15 into 2, that is 30. So plus 10 into 2. So what you do? Remember just plus 10 into 2. Plus 10 into 2. So that's how you can remember 5, 15, 30, and you will not get confused between 5, 15 and 30. 5, 15, 30. 5, 15, 30. There is one more method to remember this. 5, put one before and then into 2. So how you will remember? 5. Then in front of 5 put 1, then into 2, 30. This is how also you can remember this limit. And most importantly, you will check the total number of members as on the date of meeting. So if on the date of meeting there are up to 1000 members, then this will be quorum. If on the date of meeting there are, let's say, 2000 members, then quorum will be 15 members personally present. So you will check the total number of members as on the date of meeting, So what is a quorum? Quorum of general meeting is different for private company and public company. For private company it is 2, for public company it is 5, 15, 30, depending upon the total number of members. Don't confuse this with the quorum for board meeting. Quorum for board meeting is different. Quorum for general meeting is different. So don't confuse between quorum of board meeting and quorum of general meeting. Currently we are studying quorum of general meeting. There are few important points with respect to quorum. Quorum should be present throughout the meeting. It's not like they came, they gave their attendance and then tata bye bye. It's not like some people come, give their attendance, good evening ma'am, and then tata bye bye. That will not be quorum. Quorum, I will count quorum only those person who are with me till the end. So if you are with me till the end, then only you will be counted for quorum. If you leave in between, or if you just come and give your attendance and then leave, that is not quorum. Quorum should be present throughout the meeting. Proxy is not counted for quorum, that you already know. Next is, there is a concept of authorized representative. There are two sections, section 112 and section 113. Section 112 says that if any president of the country or the governor of the state, if the president of the country or the governor of the state is holding share in any company, then how will they attend the meeting? President will not himself go and attend the meeting now. So what he will do? He will appoint an authorized representative who will attend the meeting on behalf of him. So he appoint authorized representative under section 112. And if the president or governor appoint any authorized representative to attend the meeting, then they will be counted for quorum. Similarly, if any body corporate is the shareholder, then body corporate is not a natural person, so body corporate cannot attend the meeting. So under section 113, body corporate can appoint authorized representative to attend the meeting, and that authorized representative of president or governor or body corporate shall be counted for the purpose of quorum. And there's one point given that one person can become authorized representative of multiple body corporate. Let's say I am the shareholder of Adjournment Private Limited, Adjournment Education Private Limited, or let's say Adjournment Food Private Limited. So I am the authorized representative of these two companies. So can I go and attend the meeting on behalf of two separate body corporates? The answer is yes. So one person can become the authorized representative of multiple body corporates also. The next point is, article can provide higher number of quorum, which means that let's say there is a company named Reliance, and let's say in Reliance there are 5,000 or let's say 6,000 members. So what will be ideally what should be the quorum of Reliance? The quorum should be 30 members because it is a public company and there are more than 5,000 members. So you will say, yes ma'am, the quorum of Reliance will be 30 members. That means in the general meeting of Reliance, at least 30 members should be personally present. But let's say in article, Mukesh Ambani said no. In the article they said that our quorum is 40 members. We want stricter. We want strict. In our meeting, if 40 members will come, then only meeting will be held. Otherwise, meeting will not be held. So they specified a higher quorum in the article. Is that okay? The answer is yes. You can prescribe higher quorum in the article, and in that case, that quorum you have to comply. If you want that the quorum should be 40, then the quorum will be 40, and in that case, meeting will be conducted only if minimum 40 members will be present. So that is why here is written that article can provide for higher number of quorum. No quorum is required in case of postal ballot. What is postal ballot, sir? चिट्ठी, post. Postal ballot, नाम से ही समझ में आ रहा है. Postal ballot means resolution which you pass resolution by post. And in that case, you are not holding the meeting. So obviously there is no requirement of quorum in case you are passing resolution through postal ballot, because there is no meeting. There's one small concept that if the total number of member is less than quorum prescribed, then if all member are present, they will be deemed to be quorum. With respect to this, case law question has been asked in the past exam number of times. With this point, case law question has been asked number of times. And what does this mean? I am giving you a small concept. Let's say there are total number of member 200. Let's say there are total 500 members in a company. There are total 500 members in a company, and in the article of that company, quorum, let's say 50 is prescribed. Quorum is prescribed 50. In the article, quorum is prescribed 50. That minimum 50 member will be present, then only meeting will be held. Otherwise, meeting will not be held. And what happened? Among this 500 member, let's say 470 members died. 470 members died, or they sold their shares. Whatever happened, they just either sold their shares or they died. So how many total number of remaining members are there? Earlier there were 500 members, but among 500 members 470 died. So there are how many remaining members? Only 30 members are remaining. So if in a company there are only 30 members, then how can we bring 50 members? Only 30 members can attend the meeting now, because there are only 30 members in the company. So in this case, if the total number of members is less than the quorum prescribed, then if all members are present, then let's say if meeting may all 30 members got present, will we say that quorum is not present? No. In this case, it will be assumed that quorum is present, because there are only 30 members now. There are not 50 members. How will we bring 50 members? There are only 30 members. So if the total number of members is less than the prescribed quorum, and if all the members are present, all 30 members are present, all 30 members are present, in that case, we will be deemed that quorum is present. It will be deemed that quorum is present. I hope this point is crystal clear to you. But there is one small point, ma'am. If not all members are present, let's say among 30, only 25 were present. Among 30, only 25 were present. Then quorum is not present. Quorum will be present if all the members will be present. All 30 members will be present. I hope you are crystal clear with this point. So we are done with basically the important concepts of the quorum. Now, madam, what if quorum is not present? Let's say today only 2 students came to the class. Only 2. वैसे तो I will teach. Even if one student will come, then also I will teach with the same enthusiasm. So it doesn't matter. I'm just taking the example that let's say only 2 students were present in the class. So I said that other student it will be lost for the other student. So let's postpone this class for tomorrow. We will take this class tomorrow. Let's skip the class for today. Not many students have come. So what if the quorum is not present? We will wait for half an hour, because this is in India. If we say party is at 8, that means party is at 8:30. If we say function is at birthday celebration is at 8, birthday celebration will be at 9. This is India. So if the quorum is not present, what we will do? We will wait for half an hour. So if the quorum is not present, we will wait for half an hour. We'll wait for half an hour till the quorum get present. And even if within half an hour the quorum is not present, then If even within half an hour quorum is not present, then what we'll do? We will see that who has invited the meeting, who has brought the meeting. And you know what? If the meeting is called by requisitionist, that means that case, remember yesterday, no, not yesterday, day before yesterday I told you that if the board is not calling the meeting, then shareholders requisitionists can themselves call the meeting. And yes, if requisitionist means basically members, shareholders who are requesting the EOGM, and if shareholders are not present at the meeting, if shareholder have called the meeting and they themselves are not present at the meeting, it's like खुद का बर्थडे है खुद ही नहीं आया, खुद की शादी है खुद ही नहीं आया. It's like it's your wedding and you are not present. It's your birthday and you are not present. What? Meeting will be cancelled. Pencil से pencil, your meeting cancel. नहीं, not pencil. नजर लग जाती है इसमें. So if the meeting is called by requisitionist, then quorum is not present, then the meeting will be cancelled. And in all other cases, meeting will be adjourned to next week, same day, same time, same place, unless otherwise specified. That song, वो song है ना, same time, same जगह, same time, same जगह, अगले दिन. So it's like whenever I listen to that song, I think about that song is talking about adjourn meeting. So in all other cases, meeting will be adjourned to next week, same day, same time, same place, unless otherwise specified. Otherwise specified means you can specify some other date, and if you don't specify any date, then the meeting will be adjourned to next week. So let's say today is what? Today is 10th May now. So today is 10th May. And if let's say today quorum is not present, then ideally तो meeting will be adjourned to next week same day. मतलब today is Tuesday. So next week same day will be Tuesday. Next week same day will be 17th May. So the meeting will be adjourned to 17th May. But if we don't want meeting to be adjourned, meeting to be held on 17th May, we can specify any other date. Let's say we can specify like 11th May, or we can specify 19th May, we can specify 13th May. So we can specify any other date. But if nothing is prescribed, if no other date is prescribed, then meeting will be adjourned to next week, same day, same time, same place, unless otherwise specified, which means that if any other day, any other time, any other place is specified, then the adjourned meeting will be held on that other day, time, place. I hope this point is crystal clear to all of you. Now, ma'am, very interesting. Let's say today 2 students were present. I said that it's a student loss. It's your loss, buddy. Nothing is going. Mine, nothing is going. It's your loss. You don't come. So I said, I'm very attached to students. So I said, let's not make a very much loss of the student. Let's postpone the class for today. So we adjourned our class for tomorrow. And in tomorrow's class also students are not present. What I will do? I will say, okay, even if today also 5 students are not present, even if today also quorum is not present, doesn't matter, we will hold the class, we will hold the meeting, provided at least 2 members should be there. One student should be there. I will not teach to myself now. So if in the adjourned meeting also quorum is not present, what we will do? If in the adjourned meeting also quorum is not present, we will wait for half an hour. Let's wait. In half an hour, everybody will join. And if within half an hour also quorum is not present, then doesn't matter, the members present will be deemed to be quorum. Even if 2 members are present, it's okay, they will be deemed to be quorum, but there should be minimum 2 members. Why? Because a single person cannot do meeting with himself. Now, like I cannot teach to myself, there should be at least 1 student present. So there are numbers of students present. So minimum 2 members should be present, and if 2 members are not present, then basically it will be cancelled. So here one point is given that what if the quorum is not present? We will wait for half an hour, and if the meeting is, if even within half an hour the quorum is not present, then we will say who has called the meeting. If meeting is called by requisitionist, then it will be cancelled, and in all other cases it will be adjourned to next week, same day, same time, same place, unless otherwise specified. And if in adjourned meeting also quorum is not present, we will wait for half an hour, and if within half an hour also quorum is not present, then then members present will be deemed to be quorum. Members present will be deemed to be quorum provided there should be minimum 2 members present. 2 members present and they will be deemed to be quorum. Now there's one point that, you know, in case meeting is adjourned. So whenever a meeting get adjourned, do you need to give again 21 days notice? The answer is no. Why? Because see, here we studied that whenever you call meeting, you have to give invitation, bro, come in my meeting. So you have to go in, you have to give at least 21 days notice, 21 days invitation. But for adjourned meeting also you have to give 21 days notice. The answer is no. For adjourned meeting it's okay if you give just 3 days notice. So for adjourned meeting you need to give minimum 3 days notice. You need to give minimum 3 days notice for the adjourned general meeting. And you know what, in case of adjourned meeting, notice can be given either individually or by advertisement. Or you can, even if you don't want to give notice individually, you can make public advertisement in 2 newspapers, one in English, one in vernacular, having circulation in the district in which the registered office of the company is situated. So basically you have to give 3 days notice either individually or by advertisement. But there's one point that if your meeting is adjourned sine die. Sine die means, this is a Latin term. Sine die means for infinite period. You said, okay, meeting is adjourned, but you don't know when. I said that, okay, our class is postponed, but don't know postponed to which date. Maybe after your exams you will get a big heart attack. Oh ma'am. So if the meeting is adjourned sine die, which means meeting is adjourned but the date is not fixed, or meeting is adjourned after 30 days. Meeting is adjourned and the date of adjourned meeting is after 30 days. Then again you have to give clear 21 days notice. Then in that case also you have to give minimum 21 days notice. So this is a small point. Along with this, there is a concept of adjournment which is given in section 116. Since we studied about adjournment, that's why I am discussing section 116 together. So you know meeting can be adjourned, but you know that if the notice is, you know that if quorum is not present, then meeting will be adjourned. So if quorum is not present, meeting will be adjourned. But is that the only case when meeting can be adjourned? No, sir. You know what? In 2 situations also meeting can be adjourned. So basically, when can the meeting be adjourned? There are 3 cases given when a chairperson can adjourn the meeting. You know what? If everybody feels, let's, आज mood नहीं कर रहा है पढ़ने का, let's not study today, let's adjourn this meeting. Today we are not in a mood to study. Ma'am, let's party in physical class. So we used to say our teachers, sir, today now we don't want to study, please take us to a golgappe party. And our teachers literally used to take us for a golgappe party. And so if this would have been a physical class, I would have taken you. Okay, so you know what, chairperson can adjourn the meeting with the consent of all the members. If not all the members but majority of members. So if the members have given their consent and the chairperson feels so, then the chairperson can adjourn the meeting to some other day. Next, sometimes it's impossible to conduct the meeting. Let's say 2 persons are the shareholder, one is Rahul Gandhi and another is Narendra Modi, and both have a good fight. They had so much of fight that we are not able to transact the meeting, we are not able to pass the resolutions. So sometimes there might be disorder, there might be quarrel among members. It is not possible to conduct the meeting today. So in that case also chairperson have right to adjourn the meeting. And lastly, for the lack of quorum. So there are 3 situations in which the meeting can be adjourned. If it is impossible to conduct the meeting with the consent of all the members, in case of lack of quorum, meeting can be adjourned to some other day. And one more thing, ma'am, let's say today is the original meeting on 10th May, but today meeting could not be held, so we adjourn the meeting to 17th May. Now in adjourned meeting we passed the resolution. We passed a resolution on adjourned meeting on 17th May. So when will the resolution be deemed to be passed? You know what, resolution will be deemed to be passed on 17th May and not on 10th May. Resolution will be deemed to be passed on the date of adjourned meeting and not on the date of original meeting. Are you getting this point? That Resolution will be deemed to be passed on the date of adjourned meeting, means the date in which it is actually passed and not the date of original meeting. With this, we are done with section 116. I hope this point is crystal clear to all of you. Moving towards the next section of the day, section 104. Section 104 talks about chairman, and here we will read section 104 along with SS2. Basically, we are covering SS2 together only. Along with the provisions, we are also referring to secretarial standards SS2, which is a secretarial standards for general meeting. So what does SS2 read with? Section 104 says with respect to chairman. What does section 104 says? It says that who will be the chairman of the meeting? There must be a chairman in the meeting, na? Then only meeting can be conducted. There must be some person sitting on the crown. Basically there must be some person who's holding the chair, जो राजगद्दी में बैठा होगा तभी तो मीटिंग चालू होगी, then only meeting can be started. So who's the chairman? You can specify in your article that who will be the chairman of your meeting. So basically who's the chairman? Chairman is that person whose name is mentioned in the article. So chairperson can be mentioned, prescribed in the article. But ma'am, if nothing is prescribed in article, then ma'am, if nothing is prescribed in article, then so if there is any chairperson of the board, that if there is any chairperson of the board, then that chairperson of the board can act as the chairperson of general meeting also. Chairperson of board means board of director. There is chairperson of board of directors, who is also known as chairperson of the company. Just like Reliance chairperson is Mukesh Ambani. Similarly, if there is any chairperson of board, that chairperson can also act as the chairperson of general meeting. But ma'am, is it compulsory to have a chairman? No. So if there is no chairperson on the board, or he is not present within 15 minutes, or he is unwilling to act as a chairman, then directors present shall elect one among themselves as the chairman. So in case chairman is not present, or he is not present within 15 minutes, or is unwilling to act as a chairman, in that case directors present will choose one among themselves as a chairman. But ma'am, this is a general meeting now. If directors are not present, then if no director is present within 15 minutes, this is a very hypothetical situation which practically cannot exist, but in a very rare situation, let's say all the shareholders and directors are different, and if the no directors are present within 15 minutes, or they are unwilling to be appointed as the chairperson, then members present shall elect one among themselves as the chairman by show of hand. Show of hand means voting by hand. जो हाथ बोल रहा है हाथ उठाओ, जो ना बोल रहा है हाथ उठाओ. Show of hand means voting by hands. Whosoever saying yes, raise your hand. No, raise your hand. And if poll is demanded, then it should be taken forthwith. If you are not satisfied with the decision of show of hand, then members can also demand poll. What is poll? Basically, I'll discuss this in the coming section. And if the poll is demanded, then it should be taken forthwith. Forthwith means immediately. Forthwith is a legal term. Forthwith means immediately. Otherwise, why immediately? Because if the chairperson is not appointed, meeting cannot start. Sir, meeting can start only if the chairperson is appointed. Proper person is there in the chair. So without appointing chairperson, meeting cannot start. So that is why if the poll is demanded for the appointment of chairperson, then it should be taken forthwith. Are you getting this point? Yes, madam. Next is duties of chairman. There are some duties of chairman which a chairman has to ensure while conducting the meeting, while passing the resolutions, that proper Companies Act has been complied with, all the requirement of Companies Act has been complied with. It's the duty of chairperson to see that yes, everything is complied with, quorum is present, everything is done in fair and transparent manner, nobody is cheating now. So let's say it's like invigilator of the exam hall. In exam hall, it's the duty of invigilator na, that nobody is cheating na, everybody is writing paper properly na, everybody has signed the attendance sheet na. So is the invigilator duty. Similarly, is the duty of chairperson of meeting to ensure that all the transactions are conducted in the meeting in the fair and transparent manner, and we are following with the Companies Act. Chairperson will regulate the manner of voting. Chairperson will check proper voting is done na, proper manner, proper method has been followed now, everything. And chairperson will ensure that only those business specified in the notice are transacted. This is very important. This is very important. What does this mean? This means that in the general meeting, only those matters can be discussed, only those business can be discussed, only those resolutions can be passed which are already mentioned in the notice. Let's say there is any emergency matter, we need to immediately discuss in the meeting, but for that matter, that matter was not specified in the notice. You know what? That matter cannot be discussed in general meeting. In general meeting, only those matters can be discussed which are already prescribed in the notice. I hope this point is clear. The next point is the chairperson duty to explain various resolution before putting to vote. So whenever we chairperson put any resolution on vote, he will just explain that proper matter. He will explain that matter, and he will provide a fair opportunity of voting to all the members entitled to vote. It's the chairperson duty to check that all the person who's entitled to vote, everybody should get fair opportunity to vote, and he shall not propose if he is interested. See, if the chairperson is interested, if there is some matter or some resolution in which chairperson is personally interested, then he should not propose, he should not regulate that particular matter. For that particular matter, he should leave the meeting and he should give his responsibility to some other director or some other member. And that when that matter will be discussed, after that he can resume the meeting. So these are some small points about the chairperson. So we are done with the provisions of chairperson, and coming to the next topic, proxies, section 105. I am assuming that everybody of you have your ICSI study material with you. I am assuming that everybody of you have your ICSI study material with you. If not, please bring and come to the page number 824 of your company law ICSI study material. There you will see a topic of proxy which is given in section 105. Khushi, fresh batch will be started in June, most probably. It might differ because in June I have my brother's marriage. My own brother's marriage is there in June, so it might go some up and down, June or July, but it might start, the next batch might start in June. So it's an approximate. It might change. Most probably it will start in June or July. Okay. Now coming to the next topic, that is proxy. Proxy. What do you mean by proxy? If you yourself are not attending the meeting and you are sending somebody else on your behalf to attend the meeting, that person is known as proxy. I'll tell you the crisp points, very important points about proxy. Now be very attentive, listen very carefully. Proxy. Who is proxy? If I am the member and I am not attending the meeting myself, I'm sending somebody, let's say I'm sending Khushi on behalf of me, then Khushi is said to be my proxy. And you know what? In Companies Act, proxy has two meaning. Number one, I am sending Khushi on behalf of me to the meeting, then Khushi is known as proxy. Also, I will give right to Khushi that Khushi, you can go and attend meeting on my behalf. So I will execute a document. I will execute a written document in which I will write that I am authorizing Khushi to attend the meeting on my behalf, and that document through which I am appointing proxy, that document through which I am appointing Khushi as the proxy, that document is also known as proxy. So in Companies Act, proxy has two meaning. Number one, the person whom I am appointing in my behalf is also known as proxy, and the written document through which I am appointing, that written document is also known as proxy. Number two, ma'am, you know what? Who can appoint proxy? Any member who is entitled to attend the meeting and vote at the meeting is entitled to appoint proxy. Let's say I have right to attend the meeting and vote at the meeting, then I can appoint proxy, and proxy need not be member. Let's say I am the member of Reliance Industries Limited and I am sending Khushi on my behalf to attend the meeting. Khushi is not the member of Reliance Industries Limited. Is it okay? The answer is yes. Proxy need not be member of a company, but there is one exception, that in case of Section 8 company, proxy should be member of company. In case of Section 8 company, proxy should be member of company. So this is an important point with respect to appointment of proxy. There's one more point, that a person can become proxy on behalf of maximum how many members? So there's one point that a single person can become proxy of maximum 50 members holding 10% paid up share capital. Holding maximum 10% paid up share capital, which means that if Khushi want to become proxy of members, she can become proxy of maximum 50 members. She can become proxy of maximum 50 members and who are holding not more than 10% of the paid up share capital. Maximum, apart from that, she cannot hold proxy of those members who are holding more than 10% of the paid up share capital. Now you will say, let's say this is me. Let's say this is me and I am holding 20% shares in Reliance Industries Limited. Now can I appoint Khushi as proxy? The answer is yes. I can appoint Khushi as proxy. In that case, Khushi is already a proxy of one person who's holding 20%, which means who's holding more than 10%. In that case, Khushi cannot become proxy of any other person. Khushi cannot become proxy of any other member. Are you getting this point? That if anybody has appointed as a proxy of one member who's holding more than 20%, so that person cannot be appointed as a proxy of any other person. So there's one point that proxy, a person can be proxy of maximum, 50 members. A person can be proxy of maximum 50 members holding 10% paid up share capital. However, if one person has more than 10% of the total share, if one person has more than 10%, then he can appoint single person as a proxy. Then I can appoint Khushi as my proxy and for my entire shareholding, and such person shall not act as proxy of any other person. In that case, if I have appointed Khushi as my proxy, in that case Khushi cannot become proxy of any other person. Khushi cannot become proxy of any other person. Why? Because I am already holding more than 10%. I am already holding 20% paid up share capital. Now there is one point given here that let's say Khushi, one person has been appointed as a proxy of more than 50 members. Let's say Rajnikant. Rajnikant has been appointed as the proxy of, Rajnikant is the proxy of 60 members. Is it okay? The answer is no. You can become proxy of maximum 50 members. Then in that case, Rajnikant will be asked, sir, you are allowed maximum 50. Please choose any 50. Even if, and he should choose any 50. And even if he is not choosing any 50, then we will consider him as a proxy of only first 50 members. First 50 members who have appointed Rajnikant as a proxy, Rajnikant will be deemed to be proxy of the first 50 members and others will be not considered as valid. Remaining last 10% appointing Rajnikant as a proxy will not be considered as valid. So here this one point is given. So this is the basic concept about proxy. There is a very important concept of rights and disabilities of profit given here, and why this is crossed, all this is crossed because these are repetitive points already covered in the upper paragraph. So there is one point given, this is very important, rights and disabilities of proxy. You know what the proxy has right? Proxy has right to attend the meeting and vote only in case of poll. Why? Because in show of hand, proxy does not have right to vote on show of hand, but if the poll is demanded, then proxy can vote on poll. And you know what? Even a proxy can demand a poll. What is poll? We'll discuss just in the next few sections. So there's one point given that what are the disabilities of proxy. Means there are certain things which proxy cannot do. Proxy have no right to speak at the meeting. You are not the member, bro, you cannot speak at the meeting. So proxy is not allowed to speak at the meeting, and proxy cannot vote on show of hand. Also, proxy is not counted for the purpose of quorum. What are the rights of proxy? The right of proxy is right to attend the meeting, right to demand a poll, and right to vote on poll. So these are all the rights of the proxy. You know what? There is a time limit for depositing a proxy form. I already told you that when I want to appoint Khushi as my proxy, then I will execute a document, and in that document I will give authorization to Khushi that yes, I am appointing Khushi as my proxy. That document is known as instrument of proxy, and that instrument has to be in the form number MGT11. So what is MGT11? MGT11 is the instrument of proxy, and it should be signed by the appointer. Appointer means the person who is appointing, or my attorney. Even my attorney can sign the proxy form. Attorney means the person who to whom I have given the power of attorney. And if the appointer is any body corporate, in that case it can be under seal of the company, or it can be signed by any officer or a person authorized by the body corporate. So there's one point given that whenever I am executing the instrument of proxy, it should be in the form MGT11. But if it is not in the form MGT11, that is also okay. We can execute that in any similar format, but it should be in form MGT11. Right, and this MGT11 should be submitted to the company. I have to inform the company now. I have to inform the Reliance that Reliance, I am not coming to the meeting. I am sending Khushi in place of me. Then only Reliance will recognize now. So I have to inform to the Reliance that I have appointed a proxy and I am sending someone else in place of me. So that proxy has to be deposited at least 48 hours before the meeting. At least minimum 48 hours before the meeting, I have to deposit that proxy. And there's one point that the company cannot prescribe a time limit of more than 48 hours, but they can prescribe a time limit of less than 48 hours, which means if the company has prescribed that proxy form should be deposited, let's say 60 hours before the meeting. Can they prescribe that? The answer is no. So the maximum hours is 48 hours. Proxy form should be deposited in the company maximum 48 hours before the meeting, and company cannot specify a time limit of more than 48 hours for the deposit of proxy. I hope this point is crystal clear to all of you. Here are some general points given. As you all know that the deposit form should be properly filled, properly stamped. You know, it has to be in the stamp paper. It should be properly stamped, and it should be properly signed by the appointer. It should be properly signed by the appointer. And you know what, in case your proxy form is not properly stamped or inadequately stamped matlab you should stamp it with 100 rupees stamp and you stamped it with 50 rupees stamp paper, so it is inadequately stamped. So if your proxy form is unstamped or inadequately stamped, or it is not cancelled, you have to cancel your proxy form, like by writing this way, by writing cancel. You have to cancel it, but if you don't cancel it, then in that case proxy form will be invalid. And in case in the proxy form I have not written the name of the proxy, that will also be invalid. If the company has appointed multiple proxies, then the one that is received last to the company will be valid. So let's say I appointed Khushi as the proxy, and I appointed Khushi as proxy on 10th May. Then again on 11th May I appointed, let's say, Ankush as proxy. Sorry, if in 11th May I have appointed Ankush as proxy, then the proxy which is deposited later will be valid. So in this case, this previous will be invalid, this latest will be valid. However, if the date is not mentioned, or the time is also not mentioned, then the company is not able to figure out that which one is deposited earlier, which one is deposited later. In that case, both the proxy form will be invalid. Inspection. Who can inspect proxy? Any member who's entitled to attend and vote at the meeting, they can inspect the proxy form. But however, in order to inspect the proxy form, at least 3 days notice should be given. At least 3 days notice should be given in order to inspect the proxy form. And they can inspect proxy form during the period beginning 24 hours from the time fixed for the meeting and ending with the conclusion of the meeting, which means that any members who's entitled to vote at the meeting, they can inspect the proxy register or the proxy forms. However, they should give minimum 3 days notice in order to inspect the proxy form, and the proxy form can be inspected during the period beginning 24 hours before the time specified for meeting, which means let's say meeting will start on 10th May 10 a.m. Then members can inspect the proxy form from 9th May 10 a.m. 24 hours before the meeting until the conclusion of meeting. However, inspection can be done only during business hours, that is 9 a.m. to 6 p.m. There is a concept of revocation of proxy. What do you mean by revocation of proxy? Revocation of proxy means that, okay, let's say I thought that I will not be able to attend the meeting, that's why I appointed Ankush as my proxy, but now I am thinking no, I will attend the meeting. In that case, the proxy will be revoked. Revoke means to take back or to cancel, basically to cancel. So how will the proxy be revoked, or how can the proxy be cancelled? How can a proxy be revoked? Number one, if a fresh proxy is deposited, like earlier I appointed Khushi, now I appointed Ankush. So when I appointed Ankush, the previous proxy form which is appointing Khushi, it will be automatically revoked, it will be automatically cancelled. So if the fresh proxy is deposited, earlier one will be cancelled. If member himself attend and vote at the meeting before the proxy, I appointed Ankush as my proxy, and before Ankush could attend the meeting, Ankush could vote at the meeting, I myself attended the meeting and I myself did vote at the meeting before Ankush could vote. So in that case, I am voting at the meeting. In that case, obviously proxy will be of no use now. So if member himself attend and vote at the meeting before proxy could vote, then proxy will be deemed to be revoked, proxy will be deemed to be cancelled. And lastly, if I have given an express written revocation to the company, I have similarly written a document. In that I have written that I am revoking the proxy from Ankush, which means that Ankush is no more my proxy. I am signing that document and I am delivering that document to the company. So I have expressly revoked that. No, now I don't want Ankush to be my proxy, I want to attend meeting myself. So that is express revocation given to the company. In all the three cases, proxy will be removed. And you know what there's no need to inform to the proxy that you are fired. No need to inform. There's a concept only, you need to inform only to company. There's no need to inform to the proxy. No need. Very unfair na. Kya kar sakte hai? This is law. You don't even need to inform the proxy that bro, you are no more my proxy. Even if you don't inform to the proxy, it will be okay. You just have to inform the company. It's okay if you don't inform the proxy. कोई इज्जत नहीं है बिल्कुल. ठीक है. So this is all about the revocation of proxy. With this, we are done with our section 105 proxy. With this, we are done with our 105 proxy. The next is 106. 106 talks about voting right. Every member has a voting right. Yes, madam. Every member has a voting right. Every member has voting right. Can a company restrict voting right of any member? The answer is no. A company cannot restrict voting right of any member, but company can restrict voting right only in two cases. Number one, if that member has not paid his calls, if that member has not paid even call money, even share money, we will not give right to vote. Or that member has not given any other money, or that member has not given any money due to the company, and company have exercised right of lien. Lien means हमने उसके शेयर जब्ती कर लिए हैं. We have exercised right of lien on his shares. Like we have taken the possession of his shares pay the call money, pay the money, otherwise we will sell your share, that is lien, means taking in possession someone else's property. So normally voting right of any member cannot be restricted, but voting right can be restricted only in two situations. Number one, if any call or any other money is not paid. Number two, when the company exercise right of lien. Done. Now you know what, one important point I am going to tell you, and that important point is voting methods. There are four voting methods. There are four voting methods. In the meeting, you can vote either through show of hand, or e-voting, or through poll. And if you're not calling meeting, then there is one more method, postal ballot, chitti wala, through post. So there are four methods basically to vote: show of hand, e-voting, poll, postal ballot. 7, 8, 9, 10. 107, show of hand. 108, e-voting. 109, poll. 110, postal ballot. Now we will study this all 1, 2, 3, 4, one by one. What do you mean by show of hand? Show of hand means simply raise your hand. Whosoever is saying yes, raise your hand. Let's hold a test on Sunday. Raise your hand. Whosoever is saying no, raise your hand. That is show of hand. And usually a matter is first put to vote through show of hand. Unless and otherwise specifically e-voting or poll is demanded. When shareholders demand poll or shareholders demand e-voting, then only a matter is discussed through e-voting. Otherwise, usually, if nothing is demanded, if e-voting also not demanded, if poll also not demanded, then first a matter is discussed by show of hand. So, here one point is given, show of hand, voting by show of hand. Voting by show of hand, given in section 107. And you know what, a matter is first decided through show of hand. Unless means in two cases a matter is not decided by show of hand. Unless a poll is demanded under section 109 or e-voting is done. E-voting is done under section 108. I already told you this. Yes. And when will a resolution be said to be passed by show of hand? Let's say we said, okay, let's hold a drafting session. Let's hold a drafting session on Sunday. So I am saying whosoever is saying yes, raise your hand. And then I am saying whosoever is saying no, raise your hand. So if OR is required and majority of people have said yes, then OR will be passed. However, if SR is required, then minimum 75% people say yes, then SR is passed. So, in show of hand, when a resolution is said to be passed, when chairperson officially declare that meeting, and see, let's say the majority of people have said yes, so OR is passed. Now what, chairperson will declare the final result in the meeting, that resolution is passed. So chairperson will declare that, and that will be entered in the minutes book. So moment chairperson declare it and it is mentioned in the minutes book, it becomes the conclusive evidence that this voting was done and the resolution was passed. So what is the conclusive evidence of voting by show of hand? When the chairperson declare the result at the meeting and it is entered in the minutes book. The next section is 108. Before going to the next section, I want to tell you one small point, that we studied section 101 notice, section 102 explanatory statement, section 103 quorum, section 104 chairman, section 105 proxy, 106 restriction on voting right, 107 voting by show of hand. After that we will study 109. 109 is poll. This 101 to 107 and 109, this section is not applicable to private company if otherwise provided in article, which means that, you know what, a private company will get relief from the compliance of all this section if in the article of that private company, specifically it is said that we will not follow 101. 101 is not applicable to us, 102 is not applicable to us. Or a private company article, it is specifically some other method is written, some other law is written, some other rules and regulation is written. In that case, if anything else is prescribed in the article, if in the article they have expressly excluded this article, that to us now this section will not be applicable. In that case, this section will not be applicable to that private company. So section 101 to 107 and 109, this section will not be applicable to those private company who have specifically provided in the article, who has specifically either provided something else or expressly excluded these sections in their article. I hope you are getting this point. Now coming towards next section, section 108, which talks about e-voting. Section 108, which talks about e-voting, electronic voting. First of all, I want to tell you that e-voting is two types. Number one, remote e-voting and e-voting at meeting. E-voting at meeting. आज मैं आप लोगों का एक भ्रम तोड़ने वाली हूँ. If you think that when we are doing e-voting, it's not needed to hold the general meeting, you are wrong. You are wrong. E-voting is different. In e-voting, it is necessary to hold the general meeting. You have to hold the physical meeting as well. Even if you are giving a e-voting option, even if you are getting a e-voting option or remote voting option, घर बैठे vote करो, फिर भी आपको general meeting बुलानी पड़ेगी. Then also you have to call the general meeting. You have to call the general meeting. अब आप बोलोगे मैम वर्चुअल मीटिंग का कंसेप्ट है ना, अरे तो वो VCOAM का कंसेप्ट अलग है और अभी जनरल मीटिंग भी आप कर सकते हो VCOAM के द्वारा. दैट इज डिफरेंट. दैट वी विल स्टडी इन द वर्चुअल मीटिंग चैप्टर, दैट यू कैन होल्ड अ मीटिंग completely online. Like this class is completely online. Everybody is in the different places. There is no physical meeting. So this class is a complete online. Similarly, you can hold a complete online meeting that is known as through video conferencing or through OAVM, other audio visual modes. Video conferencing or other audio visual mode, and that is a different concept. Don't confuse it with e-voting. E-voting is simply a method of voting that you can give an electronic voting option. It doesn't mean that you don't have to hold the physical meeting here. You have to hold the physical meeting here. So don't confuse this e-voting with virtual meeting. Virtual meeting is different. E-voting is just a method of voting. Understood? Yes. And you know what e-voting says? Section 108 says that if the e-voting is applicable to you or you opt for e-voting, what you have to do, you have to give electronic voting facilities to all your members. You have to give electronic voting facility कि फोन में लॉगिन करो और वोट कर दो. फोन में लिंक में क्लिक करो, अपना लॉगिन आईडी पासवर्ड डालो और क्लिक कर दो. जस्ट लाइक यू गिव योर CSAT एग्जाम ना घर बैठे. You give your CSAT exam na in your own laptop. You just log in with your login ID password and then you give your exam. Similarly, company give e-voting facility. You can do vote with just your one click. You can just log in with your login ID password. You can click on the link and you can do voting. That is known as remote e-voting. And you know what, a company also have to provide e-voting facility in the meeting. In the meeting also there should be proper software and all through which people can electronically vote. There should be some method or link or some software through which people can vote even at the meeting. So section 101 says that if you are opting for e-voting, you have to give voting facilities, remote e-voting facility also and e-voting facility at the meeting also. Okay, and there's one point that to some kind of companies the e-voting is compulsory. Like let's say in your company there are more than 1000 members. So don't you think that yeah, obviously it's not possible for every member to attend the meeting, and there it comes the necessity of giving the e-voting facility, because not all members are able to attend the meeting. You should give them facility of घर बैठे vote करो, give vote from your home. So when in big companies, listed companies, it's not feasible, it's not possible for every member to attend the meeting, because meeting is usually held at the registered office and members are spread all over the country. So that is why here one point is given that some companies are compulsory to give the e-voting facility. And which companies are compulsory to give the e-voting facility? Number one, listed companies are compulsory to give the e-voting facilities. Those companies whose equity shares are listed on the recognized stock exchange, and all other companies who have 1000 or more members. These two companies are compulsory. These two companies are compulsory to give the e-voting facility. Number one, those companies whose equity shares are listed on the recognized stock exchange, and number two, those companies who have 1000 or more members. 1000 or more members. And here one point is given that if your equity share is not listed, here one point is given that if your equity shares are not listed, only your debentures or preference shares are listed, or you are listed on just SME trading platform, you are listed in just SME trading platform, or you are listed in just institutional trading platform. SME is basically a small and medium exchange for the small companies. So if your equity shares are not listed, only your debentures or preference shares are listed, you are listed on SME, small trading platform, you are listed on only institutional trading platform, in that case it will not be compulsory for you to give the e-voting facility. In that case, it will not be compulsory for you to give the e-voting facility. I hope this point is crystal clear to all of you. And apart from this, any other company can voluntarily also opt for e-voting. You want to give e-voting facility to your member, you can voluntarily opt for it. However, it is compulsory for some companies, those companies whose equity share is listed in recognized stock exchange, and those companies who have 1000 or more than 1000 member. Now if you give the e-voting facility, there is some procedure which you have to follow. There is some procedure which you have to follow in order to provide e-voting facility, and I will try to simplify this process for you. I'll try to simplify this process for you. This process is a very lengthy process given in your book. I will try to simplify this process for you so that it will become easy for you. Please listen carefully. What is the process of e-voting? What is the process of e-voting? And I'll try to explain this. Come here. Come here means listen to me. See what happens. What happens? Let's say this is a company and the name of the company is ITC Limited. ITC Limited is holding a general meeting on, let's say, 20th May 2022. ITC is holding a meeting on 20th May 2022. So don't you think that at least 21 days before meeting we have to give notice? We have to give notice of the meeting. We have to give 21 days clear notice, 21 days clear invitation that everybody please come to my meeting. So we have to give an invitation. And in that notice, number one thing, if you are giving a e-voting facility, in that notice, you have to specifically mention that you are providing e-voting facility. If you are providing e-voting facility, then in your notice you have to specifically mention this point that you are providing e-voting facility, and you have to mention various details. I will tell you what details. Apart from this, you also have to make one is notice, you also have to make newspaper advertisement. गांव में ढिंडोरा पिटवाना पड़ेगा, मामा ढिंडोरा पिटवा दो. So here you also have to prepare a newspaper. You also have to make a newspaper advertisement. गांव में ढिंडोरा पिटवाना पड़ेगा कि e-voting facility दे रहे हैं. So if you are providing e-voting facility in your meeting, you along with giving individual notice, you also have to make a newspaper advertisement. And one very important point that जब हम e-voting करवाते हैं, when we do the e-voting, we have to check. We have to prepare a list. Okay, this person, Mr. A is the member, he voted in favor. Mr. B voted in against. Mr. C voted in favor. So we have to check who voted in favor, who voted in against, who said yes, who said no. And then we have to check everything, and then we have to decide whether resolution passed or not. So who will do that? Board of directors? The answer is no. They appoint some experts. The board of directors of the company appoint some scrutinizer, appoint some expert to do this checking process, to do this e-voting process, and those experts are known as scrutinizer. Those experts are known as scrutinizers. So what does board do? Board appoint scrutinizer to check the votes, and facilitate this e-voting process. E-voting process. Who can be a scrutinizer? Can be a practicing CA, or can be a practicing CS, or can be a practicing CMA, or can be a practicing advocate, or can be any other person of intelligence. Either he should be practicing CA, practicing CS, practicing CMA, practicing advocate, and if he is any other person apart from this, then they should be person of intelligence, and they should have what we say, they should have the knowledge of this software and all. With this electronic voting system, they should be aware about this electronic voting system. So there's this point, and the scrutinizer can take the help of even his assistant articles and his employees, but that person should not be interested in the company. That person should not be associated with the company. So this is one point given. And what is the process? The process is that whenever we do the e-voting, first we have to provide a remote e-voting facility, and remote e-voting facility is usually 3 days. So we have to provide a remote e-voting कि जो मीटिंग में नहीं आ पा रहे हो, मीटिंग से पहले घर बैठे वोट कर लो. So whosoever is not able to attend the meeting can vote before the meeting, and this remote e-voting facility should be open for minimum 3 days. This remote e-voting facility should be open for minimum 3 days. Minimum 3 days. And it should close at last 5 p.m. At last 5 p.m. 1 day before the meeting. 1 day before meeting. So there's this process given that let's say meeting is on 20th May. So can I open my e-voting for, let's say, 18, 17 and 19th May? The answer is yes. Minimum it should be open for 3 days, 17, 18, 19. And lastly, it should close by 5 p.m. on 19th. Lastly, it should close by 5 p.m. on 19th May. That is 1 day before the meeting. So this is a small concept that we have to first provide a remote e-voting facility. Remote e-voting facility should be open for minimum 3 days, and it should lastly close by 5 p.m. 1 day before the meeting. And there is one point given that, you know, in case of big companies, the number of shareholding change every day. In big companies, shareholding change every day. So don't you think that we have to fix a date that to whom we will give voting opportunity? For that we have to fix a date. That date is known as cutoff date. So cutoff date means we have to fix a date, and of that date only we will consider members who will be entitled to vote. And that cutoff date cannot be 7 days earlier than the date of meeting, which means that if the date of meeting is 20th, then the cutoff date can be 19th, cutoff date can be 18th, cutoff date can be 17, cutoff date can be 16, cutoff date can be 15, 14, 1, 2, 3, 4, 5, 6. It can be 13th, but cutoff date cannot be 12th, which means that you have to fix a cutoff date, and you will take the cutoff date to decide who all members are entitled to vote at the meeting. And that cutoff date cannot be 7 days prior to the meeting. Sorry. That cutoff date cannot be earlier than 7 days prior to the meeting, which means that cutoff date should be 7 days prior to the meeting and not earlier than that. Only 7 days prior to the meeting cutoff date allowed. Earlier than 7 days not allowed. So cutoff date can be any of this 13, 14, 15, 16, 17, 18, 19, but not earlier than that. And all these details we have to prescribe in our notice and our newspaper advertisement. So what is the process? See, what is the process of e-voting? First, in the notice, we have to specify various details that yes, members are entitled to e-vote. We will give this date opening, e-voting opening date, e-voting closing date. We will specify the cutoff date. We will specify that you can vote only in this when the window is open only on 17th, 18th, 19th. So all this detail we will prescribe in the notice. Along with that, we also have to make the newspaper advertisement. In that newspaper advertisement also we will mention the details of the meeting, the date of opening of the e-voting and the date of closing of the remote e-voting, and the cutoff date which we will consider for deciding the number of member entitled to vote. So all these things we will mention in the notice and newspaper. After that we will provide the remote e-voting facility कि अगर आप मीटिंग में नहीं आ पा रहे, कोई दिक्कत की बात नहीं है, 3 दिन रिमोट e-voting का विंडो ओपन है, आप तब वोट कर लो. So if anybody is not able to attend the meeting, you can vote from your home only, घर बैठे window will be open, you can just click and you can vote between 17, 18, 19 by logging with your email ID and password. In notice and your newspaper advertisement also we have to mention the login ID and password, or the manner in which they can derive their password. So this also we will mention, just like you get your login ID password of CSET exam similarly. So this is how remote e-voting will be done. Now one day before the meeting at 7 p.m, 5 p.m. One day before the meeting at 5 p.m, the remote e-voting will be closed and it will be blocked. Remote e-voting window will close. Now you cannot vote. Now the window is closed. One day before the meeting at 5 p.m, the remote e-voting window will be closed and it will be blocked. And nobody can access to that data. Nobody can open it. It will be blocked. It will be closed. And now meeting day. On meeting day again, people can come, people can vote. In meeting also e-voting facility will be provided. So e-voting facility is also provided before the meeting by remote e-voting, and e-voting facility is also provided at the general meeting, at the physical general meeting. And if you have not voted through remote e-voting, then you can vote at the general meeting. If you are not able to vote through remote e-voting, then you can vote at the general meeting. However, if you have done already vote through remote e-voting, now you cannot vote at the meeting because you have already casted your vote. Vote can be casted only once and you cannot change it. You cannot vote again. However, you can attend the meeting. Let's say I have already voted. I am the shareholder of Reliance. I have already done remote e-voting. घर बैठे मैंने vote कर दिया था on 17th. Now can I attend the voting? Can I attend the meeting? The answer is yes. I can attend the meeting, but I cannot vote again. Voting can be done only once. Now there is one point that the meeting is held on 20th May 2002. Voting will be done. Now, once the voting at the meeting will be done, after that, scrutinizer will open this blocked remote e-voting result. All the people have voted electronically. This remote e-voting, that is blocked, closed 1 day before the meeting. Now during the meeting, nobody knows what is the result of e-voting or who have voted what. Nobody knows, not even scrutinizer, not even chairperson, not even director. Now once the meeting will be concluded, after that scrutinizer will open that box, scrutinizer will open that window and check. Now he will check the electronic votes. First he will check the votes at the meeting. First he will check the votes of the meeting, who voted in favor, who voted in against. He will prepare a list of that, and once the vote of the meeting will be checked, after that he will check the votes of the remote e-voting. Once the votes of the meeting is checked, after that he will check, scrutinizer will check, will open the window of remote e-voting, and then he will check the votings done by remote e-voting in the presence of 2 witnesses. That remote e-voting result can be checked in the presence of 2 witnesses, and then he will check, he will count all the votes, every vote, this remote e-voting votes also and the votes cast at the meeting also. He will count all the votes and he will prepare a report. That report is known as scrutinizer's report. In that report, he will prepare in very detail the list of members along with the shareholding and who have voted in favor, who have voted in against, everything. And this report he have to submit to the chairperson of the company within 3 days from the conclusion of meeting. So within 3 days from the conclusion of meeting, the scrutinizer have to prepare a report and he has to submit that report report to the chairperson of the meeting, like his work is done. Scrutinizer, let's say we are practicing company secretaries and we are the scrutinizer. So now we have checked all the voting, we have done everything, and we have prepared a report. Now we will go to the company's chairperson, ITC, come here, lo, I have done the work, I have checked your result. Now take this is your result, this is your voting result. So we'll submit this to the chairperson, and then chairperson will announce the result of the meeting, and the result of the meeting should be announced in all the notice board of the company, in the notice board of every offices, head office, corporate office, and also it should be published in the website of the company. So this is the whole process of remote e-voting. I am not referring the module here because this process is given in 3 pages in your module. However, I have properly explained you the whole process of remote e-voting. So I hope this is properly crystal clear to you. Can we move forward? This process of remote e-voting, is this clear to you? Bhai Arjun Singh. Okay, great. Okay, great. Everybody is crystal clear. Great. So we are done with the process of remote e-voting. आपको पता है जो क्या बोलते हैं ई-वोटिंग की फैसिलिटी हम कैसे देते हैं? अब कंपनी के पास तो इतने बड़े बड़े सॉफ्टवेयर होते नहीं है, तो यूजुअली वी टेक द सर्विसेज ऑफ NSDL, CDSL, डिपॉजिटरीज की सर्विसेज लेते हैं, क्योंकि उनका पूरा इलेक्ट्रॉनिक डेटा होता है ना, उनके पास इलेक्ट्रॉनिक डीमैट शेयर होल्डर्स का डेटा भी होता है. तो यूजुअली कंपनी डज ई वोटिंग थ्रू एक्सटर्नल एजेंसीज लाइक NSDL, CDSL. उनको आउटसोर्स कर देते हैं, NSDL, CDSL को अपॉइंट कर लेते हैं, उनको बोल देते हैं आप फैसिलिटेट करवा देना पूरा ई वोटिंग का प्रोसेस. सो कंपनी अपॉइंट्स वेरियस एजेंसीज लाइक NSDL, CDSL, डिपॉजिटरीज एजेंसीज फॉर प्रोवाइडिंग द ई वोटिंग सर्विसेज. ओके, नहीं, स्क्रूटनाइजर्स रिपोर्ट में विटनेस, हाँ, विटनेस का भी साइन होगा. यस, होगा. आते हैं उस पे भी. देखो यहाँ पर ये हो गया, कट ऑफ डेट हो गया. कट ऑफ डेट 7 दिन से पहले का नहीं हो सकता. दिस इज डन. दिस इज डन. हाँ, one more point is that जैसे जो भी वोटिंग का पूरा डेटा है, पेपर्स हैं, डॉक्यूमेंट्स हैं, all the documents, papers and all the important voting papers, they will be in the custody of scrutinizer. And once the chairperson declares the result, and then the minutes of the meeting will be prepared. So after the chairperson declare the result, after the chairman declare the result of meeting, minutes will be prepared, and once minutes will be signed by the chairperson. After that, the scrutinizer will hand over all these papers and documents to the chairperson. So before that, all the voting papers, e-voting papers, documents, everything will be at the custody of scrutinizer, because he will check now. So it will be in the possession of scrutinizer. And once the meeting will be completed, and once the minutes of the meeting will be signed, after that, scrutinizer's duty is completed, scrutinizer work is done. He will hand over all the papers, all the documents with respect to voting. He will hand over all those documents to the chairperson of the company, and basically in company, those documents will be in the custody of CS of that company secretary, or any authorized officer of that company. So this is the small point. Done, bro. Whole process of whole process of whole process of whole process of postal ballot is done. What is the report of member? What is the report of member? कहाँ पढ़े हैं आप? कहाँ लिखा है report of member? We are done with this process of e-voting. Done. डॉक्टर के पास रिपोर्ट ऑफ मेंबर तो कुछ नहीं होता है, शायद आप रजिस्टर ऑफ मेंबर की बात कर रहे होंगे. Are we clear with this? Are we clear till here? So that we can move forwards towards the process of poll. Yes. Now we can move towards poll. Now we can move towards poll. Yes. And you know what? Once you have understood the proper procedure of once you have properly understood the procedure of e-voting, you know what? Buy one get three. The process of poll is similar, and the process of postal ballot is also similar. So the now next process will be very easy for you because you have understood the process of postal ballot. Now you have understood the process of postal ballot. I will make a small one pager chart for this process of e-voting. One pager process of e-voting. I'll upload it by tonight. One pager process of e-voting in my according to my sequence in a very easy manner, and I'll upload that by tonight. Now there is another process of demand of poll. And what do you mean by poll? So there are some important points with respect to poll. What do you mean by poll? Poll is given in section 109. What do you mean by poll? Poll is given in section 109. Poll means basically when the voting is done by poll, it is not done by show of hand. Show of hand means you are raising your hand. Who's saying yes, raise your hand. Who's saying no, raise your hand. So that is show of hand. But what do you mean by poll? Poll means basically you are given a polling paper. इसको क्या हो रहा है? Poll means basically you are given a polling paper in which the resolution is mentioned, the matter is mentioned for which you have to pass the resolution. Let's say we are passing a resolution for, we are conducting a voting for, let's say, a question that let's hold nahi resolution to hold drafting session on Sunday. Not Sunday. So क्या हो रहा है? 17th May. So here two options are given to you. Number one, yes. Number two, no. So basically in poll now, you are not asked to raise your hand, but you are given a polling paper. In that polling paper, there is a resolution and then there is a assent or dissent option. You can give either your assent or you can give your dissent. Also, you can vote nota. None of the above. So there is a voting option in the polling paper. This voting through polling paper is known as poll. Now there is one important point, that even a proxy can demand a poll and even a proxy can vote on poll. And there is one major difference which I want to tell you, that usually in a voting, this is very important point, that usually in a voting, when we do show of hand, like if I am one person, I can raise only one hand or maximum two hands. But is it like if I have 100 shares, can I raise 100 hands? The answer is no. Whenever a voting is done through show of hand, it is always one person, one vote. One person will get one vote. But when I talk about poll or when I talk about e-voting, the voting is not one person, one vote. It's one share, one vote. So basically, if you have 10% shares, then you will get 10% vote. If you have 50% share, you will get 50% vote. So, but only in case of show of hand, only in case of show of hands, since you have only two hands, you can not have like 10 hands like a Ravan or unlimited hands. So that is why in case of show of hand, the voting is only done like one person, one vote, one person get one vote. However, whenever poll is demanded or e-voting is done, voting is always on the basis of shareholding. On the basis of your shareholding only, you derive the voting power. How much shares you have? If I have 100 shares, I'll get 100 vote. I have 10% shares, I'll get 10% vote. So usually in case of poll e-voting, it is one share, one vote. Now the question is, can we demand a poll? The answer is yes. Can a poll demanded? Now the next question is, when can a poll be demanded? When can a poll be demanded? Poll can be demanded before the resolution is passed through show of hand or even after the resolution is passed through show of hand. Let's say सब आ गए हैं मीटिंग में, everybody has gathered for the meeting and we are about to start the meeting, and now for passing the resolution, before show of hand could be done, everybody said no, we don't want show of hand, we want voting by poll. So if they are demanding poll even before show of hand, can they demand? Yes, they can directly demand show of hand. In that case, they can directly demand poll. In that case, show of hand will not be done. Now secondly, let's say we have done show of hand, we have passed a resolution through show of hand, and if the members are not satisfied, then even after the declaration of result of show of hand, even after the voting through show of hand, poll can still be demanded. So you know what, poll can be demanded even before the resolution is passed through show of hand or even after the resolution is passed through show of hand. Now the question is, who can demand poll? कौन डिमांड कर सकता है पोल? नंबर वन, चेयरपर्सन. चेयरपर्सन कैन हिमसेल्फ डिमांड पोल. चेयरपर्सन के पास बहुत राइट है, बोल दिया ना पोल करेंगे तो पोल करेंगे. चेयरपर्सन कैन हिमसेल्फ डिमांड पोल, ही हैव लॉट ऑफ राइट्स. एंड यू नो व्हाट, इवन मेंबर्स कैन डिमांड द पोल. बट मेरे पास एक शेयर है, मैं बोलूंगी रिलायंस को ए पोल कर, तो वो कर लेगा क्या? नहीं करेगा. So it's like if one member will say it will not hold the poll for one member, there should be minimum 10% member. So even members can demand poll, but at least minimum 10% of members should demand poll. So minimum members can also demand poll. What is the requirement of minimum number of members who can demand a poll? That is different in case of company having share capital and company not having share capital. For company having share capital, minimum those members who are holding 10% of the TVP or 5 lakh paid up share capital, whichever is less. 10% of TVP or 5 lakh paid up share capital, whichever is less, they can demand a poll. In case of company not having share capital, those people who are holding 10% of the TVP. TVP means total voting power. And usually if the shares are not differential rights, then usually in case of ordinary equity shares, TVP is dependent on in paid up share capital only, in shareholding only. If you have 10% share paid up share capital, you will have 10% of TVP. In a normal circumstances, unless and until you are issuing a DVR, differential voting right share, right? So in case of company not having share capital, you will see 10% of TVP. You will see 10% of those members who are having holding 10% of total voting power, they can demand a poll. And you know what? Here I have written including proxy, which means even proxy has right to demand a poll. I hope you are getting this point. And you know what? पोल ना दोगुला है, मेंबर्स ना दोगुले हैं. दोगुले हैं, एक बार डिमांड कर लिया ना पोल, विड्रॉ भी कर सकते हैं। नहीं नहीं मन चेंज हो गया, अब नहीं करना है, विड्रॉ कर सकते हैं, अब मत करो। तो डिमांड करने के बाद पोल कैन बी विड्रॉन, डिमांड ऑफ पोल कैन बी विड्रॉन, डिमांड ऑफ पोल मे बी विड्रॉन, मेंबर्स दोगुले हैं, डिमांड्स ऑफ पोल मे बी विड्रॉन, मेंबर्स दोगुले हैं, demand of poll may be withdrawn. There's one point given that if any poll is demanded for any matters, it should be taken within 48 hours. If the poll is demanded, तो भैया तुरंत कैसे लेंगे, पोलिंग पेपर्स वगैरह अरेंज करना होता है, अरेंजमेंट्स करनी होती है, पेपर्स वगैरह बनाना पड़ता है, सो इट टेक्स टाइम. सो देयर इज मिनिमम 48 minimum time given that the poll should be taken within 48 hours. So if the poll is demanded, in case the poll is demanded, in case the poll is demanded, then the poll should be taken within 48 hours. However, in two case, we will not wait for 48 hours. Poll should be taken immediately, forthwith. So if the poll is demanded, then poll should be taken within 48 hours. Poll is demanded, it should be conducted within 48 hours. But in two situations, it should be conducted immediately, forthwith. One we already know, in case of appointment of chairman, and secondly in case of adjournment of meeting. If the poll is demanded for these two matter, for adjournment of meeting or for appointment of chairperson, then the poll should be taken immediately. Otherwise, poll should be taken within 48 hours. 48 hours. I hope this point is crystal clear to all of you. What is the manner of poll? Again, the process is given, and you know what? The process is similar. The process is similar. You know what? You know what? Now, when a poll is demanded, we have to make a polling papers, like polling papers in which we will write the resolution and we'll give a 2 check box. If you are saying yes, you can tick on this. If you are saying no, then you can tick on this. So this is basically polling papers. So what we have to do, in case we are holding a poll, we are doing a voting by poll, then we have to prepare these papers, we have to print out these papers, we have to submit these polling papers to all the members, and then we have to do the voting. After the voting is done, we have to collect all the papers and we have to count. We have to check, okay, this Mr. A voted yes, this Mr. B voted no, this Mr. C voted yes. So we have to count all the votes, we have to check. Who will do that? Who will do that? Chairperson? No. Board of directors? No. They will appoint experts for conducting this poll, for checking all the votes, for facilitating this poll process. Who are those experts? Those experts are known as scrutinizers. Who can be scrutinizer? Sir, same we studied na. Arey, e-voting wala scrutinizer, here same. Who can be scrutinizer? PCA or PCS or PCMA or practicing advocate or any other person who have competence and who is not associated with the company, who does not have any interest in the company, and they can take assistance of any employee who is not interested with the company. So basically, board have to appoint the scrutinizers who will facilitate the polling process. What they will do, they will prepare the polling papers, and once the meeting will be done, and you know what they have to do, they have to prepare a box, and that box has to be, let's say this is the tala, this is lock. There is a box, this box is known as polling box. This box is known as polling box. You know what? Scrutinizer have to prepare one polling box and it should be locked. It should be locked. ताला लगा हुआ होना चाहिए इसमें properly. इस lock में proper it should be locked with a key and it should be empty from inside. अंदर से खाली होना चाहिए और ताला लगा हुआ होना चाहिए. And we will ask people to vote and then उनका पेपर को फोल्ड करके हम इसके अंदर डाल देंगे, जैसे चिट्स डाल देते हैं ना खाली डब्बे में, वैसे ही. So here one point is given that in order to facilitate the polling process, what we will do, the scrutinizer will prepare a polling box. That polling box have to be empty and locked, and we will give polling papers to everybody for casting their vote. And once the vote will be done, we will take polling papers and polling papers should be put in that. ऊपर से एक उसमें होल रहेगा डालने के लिए, पेपर्स डालने के लिए. So people can put their votes, their polling paper after voting in that polling box and that box should be locked. वो जब तक voting खत्म नहीं होगी, जब तक meeting खत्म नहीं होगी, वो box खुलेगा नहीं. That box will be closed. That polling box will be closed. So here one point is given that scrutinizer will prepare this polling box, polling papers, everything, and then in meeting voting will be done. Everybody will give poll papers, and after the voting will be done, then after the conclusion of meeting, after the meeting will end, scrutinizer will open this box, scrutinizer will open this khajana, scrutinizer will open this box in the presence of two witness. Same just like e-voting, he will open this box in the presence of two witness, and then he will check everything. He will prepare a list, किसने favor में vote किया, किसने against में vote किया, everything he will check, and then at last he will prepare a report. That report is known as scrutinizer's report. He will prepare scrutinizer's report. In that report he will give the final conclusion कि क्या हुआ, resolution pass हुआ कि नहीं, whether resolution passed or not, who voted in favor, who voted in against, every detail, and then we'll prepare a report. And we have to submit this report, to the chairperson of the meeting, within how many days? Within 7 days. Within 7 days we have to prepare the scrutinizer's report, and we have to submit this report to the chairperson of the company. Why 7 days? वहां तो 3 दिन था. अरे सर, there it was electronic. e-voting काउंट करना डिफिकल्ट नहीं होता है, बट यहाँ फिजिकल पेपर्स होते हैं, पोलिंग पेपर्स, उसको काउंट करने में समय लगता है. So here there are physical papers, that's why here it is given 7 days. There everything was electronic, सॉफ्टवेयर के थ्रू सब हो जाता है, मेहनत नहीं होती उसमें. So इसलिए there in e-voting 3 days time was given to submit the scrutinizer's report. In case of e-voting 3 days time was given to submit the scrutinizer's report. However, in case of poll 7 days time is given to submit the scrutinizer's report, and then scrutinizer will count all the votes, submit the scrutinizer report within 7 days to the chairperson, and then chairperson will announce the result of the meeting. Result should be announced in all the newspapers, not newspaper, in all the notice board of the company, in the website, everywhere. So this is how the voting is done through poll. I hope you are crystal clear with the process of poll. One more thing, this polling paper is in the form number MGT12. We have studied MGT11, proxy form. Basically proxy form is MGT11, and this polling paper is in MGT12. This polling paper is in MGT12. So these are the forms of this chapter. I have already told you that all the forms of this chapter will be in MGT. And you know what? This scrutinizer's report will be in the form number MGT13. This scrutinizer's report will be in the form number MGT13. So we are done with 3 forms: MGT11 proxy form, MGT12 polling paper, MGT13 scrutinizer's report. You can write it somewhere. Okay, we are done with this, and we are done with the poll 109. Now coming to the next section, 1010 postal ballot. अमन, आज ही हो जाएगा चैप्टर कंप्लीट. स्नेह, हिंदी मीडियम में तो भी आप कर सकते हैं, कोई दिक्कत वाली बात नहीं है. यू शुड टेक प्रॉपर क्लास. आपको प्रॉपर क्लास लेनी चाहिए. रेगुलर क्लास आपने ली होगी तो आप कर सकते हैं. ऐसा नहीं है कि हिंदी मीडियम से है तो नहीं कर सकते हैं. मैथ्स से है तो भी कर सकते हैं. यहाँ मेरी एक बच्ची प्रेजेंट है, सोनल. शी इज फ्रॉम मैथ्स, शी इज फ्रॉम बायो, स्टिल शी इज डूइंग एंड शी इज डूइंग गुड. सो ऐसा जरूरी नहीं है कि आप हिंदी मीडियम से हैं या आप मैथ्स से हैं तो आप नहीं कर सकते. इट्स नॉट नेसेसरी, आप बिल्कुल कर सकते हैं. एंड ये चैप्टर आज ही कंप्लीट हो जाएगा. हो गया है, मेजर पार्ट हो गया है, 110 हो जाएगा. उसके बाद बस छोटे मोटे सेक्शन बचेंगे. 9:30 बजे तक कर लेंगे, 9:30 तक. ठीक है, 9:30 class will go till 9:30. We will do this chapter by 9:30. Next is the postal ballot process. Postal ballot, there's one shortcut to remember this section. And what is the postal BA110T. postal ballot. So this is how you can remember section 110. This is the section for postal ballot, BA110T ballot. So the section for postal ballot is 1110. अब मैं कुछ बेसिक बातें, बहुत ही जरूरी बातें आपको बताने वाली हूँ सेक्शन 1110 से रिलेटेड. नंबर 1, whenever a matter is discussed through postal ballot, तो उस केस में ना voting is not done at meeting. See, in e-voting na, in e-voting, we were also doing remote e-voting and we were also giving voting option at the meeting. तो वहां मीटिंग भी हो रही थी, मीटिंग में भी वोटिंग हो रहा था. बट इन केस ऑफ पोस्टल बैलेट, please understand that no physical meeting has been held. Voting is not done physically at the meeting. Voting is only done through chitti, through post. Post. We are giving them post. That sir, संदेशा, प्रेम पत्र. सो हम एक पेपर, पोस्टल बैलेट पेपर बना लिए, उस पेपर में रेजोल्यूशन लिख दिया, 2 डब्बा कर दिया. आप अगर यस बोल रहे हो तो इसमें करो, नो बोल रहे हो तो इसमें करो. सो दिस इज जस्ट लाइक वी प्रिपेयर्ड रेजोल्यूशंस, दिस पोस्टल बैलेट पेपर्स. एंड व्हाट वी विल डू, वी विल डिस्पैच दिस पोस्टल बैलेट पेपर टू योर एड्रेस. लेट्स से यू ऑल आर द शेयर होल्डर्स ऑफ एडुमेंशन प्राइवेट लिमिटेड. सो एंड इफ any matter is been discussed through postal ballot, what I'll do, I'll prepare this polling papers in which I will write all the resolution, and I will dispatch this physical polling papers to all your address, to Mehboobi address, to Aman address, to Vivek address, to all the people address. I will dispatch this postal ballot papers to your physical registered address, and then I'll ask you, चिट्ठी खेलेंगे हम, मैंने चिट्ठी के थ्रू आपको भेजा, आप अपना वोट टिक करके मेरे को चिट्ठी भेज दो, चिट्ठी. So you will play post. So we have posted you the letter and you can do your vote, you can tick your vote, you can just do your vote, and then you can again give that letter back to the company. You can submit that letter again back to the company. That is the process of पोस्टल बैलेट. चिट्ठी मीटिंग में वोटिंग नहीं हो रही है, हम चिट्ठी के द्वारा भेज के वोटिंग करवा रहे हैं. दैट इज पोस्टल बैलेट प्रोसेस. वोटिंग इज नॉट डन एट द मीटिंग. आर यू गेटिंग दिस पॉइंट? यस मैडम, बहुत अच्छे से. ठीक है. अब देखो यहाँ पर क्या होता है पोस्टल बैलेट में, whenever a postal ballot is done, we give them 30 days time कि आपकी हाँ या ना 30 दिन में आ जानी चाहिए, उससे ज्यादा नहीं रुकेंगे. It's like I have given a love letter. I know I will not give love letter to anybody. Let's say Salman Khan has given a love letter to Katrina Kaif. So Salman Khan has given a love letter to Katrina Kaif and asking, will you marry me? तो Katrina Kaif, Salman Khan said, I will wait for 30 days. 30 दिन में जवाब आ जाना चाहिए. You should reply. I should receive your reply within 30 days. And if you don't reply within 30 days, I'll assume that it's your no. And I will marry someone else. So Salman Khan will say, I'll wait for 30 days. If your reply doesn't come in 30 days, I'll marry someone else. So this is how we give them a letter and we ask them to vote, and their vote should be received to the company within 30 days. And if their vote is not received within 30 days, then we will assume that they have not casted their vote. And if their vote is received after 30 days, then also we will not consider. Sir, once opportunity gone, always gone. अब मुझसे शादी करने का मौका नहीं मिलेगा, 30 दिन का समय दिया था, अब नहीं कंसिडर करेंगे. अब क्यों आ रहे हो, अब मैं ऑलरेडी शादीशुदा हूँ. So it's like if your vote is received after 30 days, then we will not consider your vote. So this is the small process of postal ballot. So what is the section for postal ballot? Section 110. There are certain matters which can be transacted only through postal ballot. So there are certain matters which can be transacted only through postal ballot. Meeting में नहीं करोगे, चिट्ठी के द्वारा ही करोगे. So there are certain matters which can be transacted only through postal ballot. Number 1, if you want to change the object clause of the company, SBC में पढ़े हो ना, alteration of object clause. So if you want to alter the object clause of the memorandum, then that for altering the object clause, what you have to do, you have to pass special resolution. That special resolution can be passed only through postal ballot. Next is alteration of article for insertion or removal of the provisions defining a private company. You know na, in private company there are 3 restrictions in the article, but in public company there are no restriction in the article. So if you are converting a private company to public company or a public company to private company, you have to add or delete meet those 3 restrictions? Yes. So for that you have to alter the article. So if you are altering the article for the purpose of conversion, for the purpose of addition or deletion of those 3 restrictions, then for that you have to pass special resolution. That special resolution can be passed only through postal ballot. Next is, if you want to change your registered office outside the local limit of your city, town or village, in that case, that resolution you have to pass through. What you have to pass? Again, special resolution. That special resolution you have to pass through postal ballot. If you want to change the object of the company for which you have raised money through public prospectus and any money is unutilized, you have raised the public money through prospectus, and now you want to change the object for which that money will be utilized, that can be done by passing special resolution, and that special resolution can be passed only through postal ballot. Next is issue of shares with differential voting right. Remember section 43, you want to issue DVR? Yes, you have to pass ordinary resolution, and to issue DVR, differential voting right shares, you can pass resolution only through postal ballot. Next is section 48, variation of shareholders right. Whenever you want to vary the shareholders right, that can be done only through postal ballot. You have to pass special resolution. That special resolution can be passed only through postal ballot. Buyback, you have to pass ordinary resolution for buyback. That OR can be passed only through postal ballot. Next is election of small shareholder director. If you want to elect any small shareholder director, we will revise in section 151 tomorrow. That election, resolution can be passed only through postal ballot. If you want to sell your undertaking, if you want to sell your company, then you can do so. Only you have to, you can pass that resolution only through postal ballot, discussed in section 180. If you want to give loan, guarantee, security or investment exceeding the prescribed limit, then you have to pass special resolution under section 186. That resolution can also be passed only through postal ballot. So all these are the resolutions which can be passed only through postal ballot. This is very important. You have to remember this. The matter which can be discussed only through postal ballot. How will you remember? 3 points are related to 4 points are related to alteration of MOAOA, which we have studied in SBEC. There is a proper chapter, alteration of MOAOA. So 4 points are related to alteration of MOAOA. Number 1, alteration of object clause, and number 2, this alteration of object for which the public money is raised through prospectus. Number 2, alteration of registered office outside the local limit. Number 4, alteration of article for conversion. So this 4 points are related to alteration of MOAOA. So you can link them 4 together. Next 3 points are related to shares. Next 3 points are related to shares, like issue of DVR, variation of shareholders right, or buyback of shares. So these 3 points are related to shares, and next 3 points are related to director, like election of small shareholder director, sell of company, and giving loan, guarantee, security, investment. So these 3 are basically from your part B. So these 3 sections are from your part B. So this is how you can link to remember how you can link 4 plus 3 plus 3. 4 are alteration related, 3 are shares related, and 3 are board related. Okay, so this is how you can remember all these matters which can be discussed only through postal ballot. Apart from this, any other matter you have option, either you can discuss through postal ballot or you can discuss through physically at the meeting. But you know what, few companies are not required to conduct any matter through postal ballot. Few companies are exempted, that आप अगर postal ballot नहीं करोगे चल जाएगा. Number 1, 1% company. क्यों? एक ही तो member है, जरूरत ही नहीं है. No need, there is only one member. There is no need of postal ballot in case of OPC. Next, if in your if in your company there are maximum 1200 members, no need of postal ballot, you can hold the physical meeting. So, 2 companies are not required to hold any matter through postal ballot, to transact any matter through postal ballot. Number 1, OPC, 1-person company, and number 2, all the other companies having membership up to 200. All the other companies having membership up to 200. So, this is a small point. And you know what? If all these matters which are required to be transacted through postal ballot, they can be transacted at the meeting if e-voting facility is provided. So all those matter which we studied that this can be transacted only through postal ballot, they can be discussed even at the meeting if the e-voting facility is provided. So which means that they can be discussed even through e-voting also. They can be discussed even through e-voting also. So this is the small point. Now there is one point that 2 matters can never be discussed through postal ballot. 2 matters can never be discussed through postal ballot. Number 1, ordinary business. Why? ordinary business can be done only at the AGM. No postal ballot allowed, sir. उसको तो AGM बुला के ही करना पड़ेगा. Ordinary business अड्डा can be discussed only and only at the AGM. They cannot be discussed through postal ballot. So ordinary business आप postal ballot के थ्रू कभी नहीं कर सकते. अड्डा ADDA, remember section 102. Ordinary business, adda, ADDA, yes. So ordinary business can be transacted only at the AGM. They cannot be transacted through postal ballot. And secondly, any other matter in which the auditors or directors have right to be heard, which means they have right to speak, that can be transacted through postal ballot. Why? Because postal ballot is like voting through post, voting through chitti. And if there is any matter in which auditors have right to speak, directors have right to speak, which means we have to physically hold the meeting where the discussion have to be done, then only voting will be done. So that is why if there is any matter where the directors or auditors have the right to be heard, they have right to speak, that matter cannot be discussed through postal ballot. Though these two matters can never be discussed through postal ballot. These two matters can never be discussed through postal ballot. I hope this point is crystal clear to you. Now, what is the process of postal ballot? And trust me, you have studied the process of e-voting now. Similar. Process is similar. Don't take the headache of this 3-pager processor. 1, 2, 3, 4. Don't take headache of this 4-pager processor, because process is very easy and process is similar. We studied the whole process of e-voting. The process of e-voting, process of poll, process of postal ballot, all these are similar. So is one point given, what is the process of postal ballot? What we have to do, we have to prepare the postal ballot papers, we have to prepare the ballot papers, and we have to dispatch it to the registered address of the shareholders. We have to dispatch this ballot papers along with the notice to the registered address of the shareholders. And you know what, there's one point given that हम इसको physically भी भेज सकते हैं या फिर हम इसको email के द्वारा भी भेज सकते हैं. ऐसा जरूरी नहीं है कि physical papers ही भेजो, आजकल electronic का जमाना है. You can even send an email or a electronic ballot papers you can send. Electronic ballot papers you can send. So there's one point given that this electronic this ballot papers can be either sent physically at the physical address of the members, or even it can be given sent through electronic mode like email or any other electronic facility. In that case, we will ask them to submit their vote also electronically, like we will ask them to email back or to upload it in the given link. So this ballot paper can be provided physically at the registered office, or even this can be provided through like electronically. This can be provided even electronically, ballot papers. Okay, so we have to provide the ballot papers to the shareholder, and they will cast their vote. They will cast their vote and vote कर दिए वो लोग, और फिर मान के चलो यहाँ पर है option yes or no का, and they have voted. This is the paper. Let's say this person voted in yes, so he voted, and then he have to submit back this ballot paper to the company. He have to submit back this ballot paper to the company, and company should receive this signed ballots within 30 days. Within 30 days, otherwise after 30 days it will not be valid. So company should receive the signed ballot papers and the voted ballot papers within 30 days. Okay, and you know what, this ballot paper should be properly signed. It should be properly signed by the member. And then again we have to count all the votes, yes or no, किसने yes में vote किया, किसने no में, who voted in favor, who voted in against. So for that we have to appoint experts. Those experts will be scrutinizer chairperson will appoint scrutinizer will check all the votes, who voted in favor, who voted in against. So everything will be checked, and he will check who voted in favor, who voted in against, and then he will prepare a report. That report is again known as scrutinizer's report, and that report he has to finally, when every vote is checked, उसने देख लिया किसने क्या वोट किया, पूरा प्रोसेस हो गया. Now scrutinizer will submit this scrutinizer's report to the chairperson of the company within 7 days. यहाँ भी 7 days का टाइम मिला है, that this scrutinizer will submit this report to the chairperson of the company within 7 days. Within 7 days of the meeting, he will submit this report, and then chairperson will chairperson will announce the result of the meeting. वो ऐसे भी announce कर सकता है कैसे, normal this result of the postal ballot, this result of the postal ballot should be announced in all the notice board of the company and all the notice board जो होता है ना company के बाहर physical office में. So outside the notice board of the head office, outside the notice board of the corporate office, outside the notice board of the branch office, we have to publish this result of postal ballot, and also we have to publish the result in the website of the company. And you know what, also हम लोग अलग से meeting भी बुला सकते हैं सिर्फ रिजल्ट डिक्लेयर करने के लिए. उस मीटिंग में वोट नहीं होगा, बट सिर्फ रिजल्ट डिक्लेयर करने के लिए भी मीटिंग बुला सकते हैं. बट उस मीटिंग का कोई पर्पस नहीं होगा. बेसिकली उसमें वोटिंग कुछ नहीं होगा. उसमें बस जो चेयरपर्सन है वो रिजल्ट डिक्लेयर करेगा कि देखो आपने हमने जो चिट्ठी के द्वारा वोटिंग करवाई थी उसका ये रिजल्ट है. दैट्स इट. So chairperson can even hold a meeting to just to declare the result. No voting will be done in that meeting, no discussion will be done. Just to declare the result, chairperson can hold a meeting later on. But in case of postal ballot, physical meeting is not required. If chairperson want, he can hold a meeting just to declare the result. But in case of postal ballot, the voting is done through post, and here the no requirement of physical board meeting is there. Not board meeting, no requirement of physically holding a meeting is there. Okay, so basically this is the whole process of postal ballot. I hope this process of postal ballot is clear to all of you. There's one small point that you will give this ballot papers along with the notice, and you know what, this notice have to be given even to the directors, auditors, debenture trustees, even though there is no meeting, even though they are not entitled to vote, but still this notice of the postal ballot should be given to the directors, auditors, secretarial auditors, debenture trustees, etc. We can also give them e-voting facility. Like postal ballot means no physical meeting is not been held. We are only giving them option to vote through post. So we can electronically also give them ballot papers, and we can ask them to vote electronically also. So here postal ballot, you know what, in postal ballot also voting can be done electronically. In postal ballot also voting can be done electronically. So we can give them e-voting facility. And here when we are giving the e-voting facility now, then you also have to follow that section 108. Why? Because we are giving e-voting facility. So in that case you also have to follow the procedure of this postal ballot, and you also have to follow the procedure of e-voting. So you have to follow the procedure of e-voting as well as postal ballot. Let's say if there is some person, उसने चिट्ठी के द्वारा भी वोट कर दिया, ई वोट के द्वारा भी वोट कर दिया. So if there is some person who have voted both by way of post and by way of e-voting, then in such a case the vote by post will be invalid. Why? E-voting will be valid. So if there is some person who have voted through both the method, by post also and by e-voting also, then his vote by post will be invalid. चिट्ठी क्यों भेजा? आपका चिट्ठी invalid हो जाएगा अगर आपने e-voting भी कर दिया है तो e-voting will be valid. और इस केस में भी आपको न्यूज़पेपर एडवर्टाइजमेंट करना पड़ता है. जस्ट लाइक आई टोल्ड यू ना दैट इन केस ऑफ ई वोटिंग यू हैव टू मेक द न्यूज़पेपर एडवर्टाइजमेंट ऑल्सो. गाँव में ढिंडोरा पिटवाना पड़ता है कि ई वोटिंग की फैसिलिटी प्रोवाइड कर रहे हैं. सो हियर ऑल्सो व्हेन यू आर प्रोवाइडिंग व्हेन यू आर पासिंग अ रेजोल्यूशन थ्रू पोस्टल बैलेट, यू हैव टू मेक अ न्यूज़पेपर एडवर्टाइजमेंट, one in English, one in vernacular, having circulation in the district in which the registered office of the company is situated. और advertisement में क्या लिखोगे? बहुत ही basic सी बात है. What you will write in advertisement? You will write the date in which the notice is dispatched, date of commencement of voting, date of end of the voting, and you have to compulsorily mention this statement that आपको 30 दिन के अंदर अपना रिप्लाई दे देना है. योर रिजल्ट, योर वोट शुड बी रिसीव टू द कंपनी विद इन 30 days. इफ इट इज नॉट रिसीव विद इन 30 days फ्रॉम द डेट ऑफ डिस्पैच ऑफ नोटिस, देन इट विल बी कंसिडर्ड एज इनवैलिड. सो योर वोट should be received to the company within 30 days from the date of dispatch of the notice, otherwise it will be treated as invalid. I hope this point is crystal clear to all of you. All other points are same, all other points are already explained, and there is one common point among all, that all the ballot papers and all the voting details, all the voting papers will be in the custody of scrutinizer. And when the meeting will be held, meeting result will be declared, and when the minutes will be approved, minutes will be signed by the chairperson. At that point of time, scrutinizer will submit this scrutinizer's report. At that point of time, scrutinizer will hand over all the voting papers, ballot papers, e-voting papers to the chairperson, and then they will be in the custody of CS of the company. So this is one small point. Last point of the postal ballot is, postal ballot will be invalid in any of this situation. So this 4 marks question can be asked, 4 or 5 marks question can be asked, that when can a postal ballot be considered as invalid? When can a postal ballot be considered as invalid? So it's very easy point. मान के चलो कि I voted but I didn't put my signature. In that case, ballot will be valid? No, there should be your signature in that. And let's say the signature in the ballot is not matching with the signature of that member in the records of the company, then also ballot paper will not be valid. So मैंने जो vote किया, मेरा vote valid कब नहीं होगा? My voted ballot paper, it will be invalid in which situation? Number 1, if it is in the form other than one issued by company. कंपनी जो बैलेट पेपर आपको देती है उसी में आपको टिक करके देना रहता है, आप कोई दूसरा पेपर यूज नहीं कर सकते. सो इफ यू आर यूजिंग सम अदर फॉर्म एंड नॉट द फॉर्म इश्यूड बाय कंपनी, देन योर वोट विल बी इनवैलिड. नेक्स्ट, if it is signed, if it is not signed, you just voted and you didn't sign, then also it will not be valid. Signature is not matching, then also it will not be valid. If it is not able to determine whether you assented or dissented, let's say there was 2 box 1 and box 2. Box 1 was for yes and box 2 was for no. What you did? You did this. Is it possible to determine whether you are saying yes or whether you are saying no? ये क्या होता है? What is this? So if it is not able to determine that whether you are giving your assent, हाँ, or dissent, no, then that your ballot paper will be invalid. You neither assented nor dissented, आपने कुछ टिक ही नहीं किया, जैसा पेपर आया था वैसा का वैसा भेज दिया. You neither put in yes, you neither put tick in yes nor in no. So in that case, your ballot paper will be invalid. The competent authority, आपका वोटिंग राइट फ्रीज हो गया. समटाइम्स द एनसीएलटी और द NSDL CDSL depository freeze your voting rights if there is any dispute. So if your voting right is freezed, in that case your ballot paper will be invalid. If your envelope containing the postal ballot is received after the last date, आपका बैलेट पेपर 30 दिन के बाद आएगा तो नहीं रिसीव करेंगे. if your ballot paper is received after 30 days, it will not be valid. If it is signed by a legal representative not accompanied by the copy of relevant signifying authority, which means, let's say in case of company, your legal representative signs the ballot paper, along with that you also have to attach the document which is authorizing that person to sign. So that authority letter also you have to attach along with the ballot paper. If you have not attached that authority paper, then your ballot paper will be invalid. If your calls in arrears, if you have calls in arrears, you are not entitled to vote. Next is if it is defaced or mutilated. मतलब defaced मतलब पूरा cut, or not able to read. Defaced means not able to, somebody is not able to read. और mutilated, it is either ऐसा मोज देते हैं पेपर को, अब उसको खोले तो उसमें वर्ड्स उखड़ गए, आप पढ़ नहीं पा रहे हैं basically. If that paper is defaced or mutilated, it will be invalid. If any amendments is made, amendment मतलब पहले आप yes में टिक किए थे, बाद में आपने yes को क्रॉस करके no में टिक कर दिया. Changing not allowed. एक बार कर दो जो करना है सोच समझ के. So if you have made any amendment means changes, then your ballot paper will be invalid. This is an important question, that in what all circumstances your ballot paper will become invalid. A resolution passed through postal ballot cannot be cancelled, but it can be cancelled only through another postal ballot. So if you want to cancel any resolution which is passed through postal ballot, it can be cancelled only through another postal ballot. And once the resolution is issued in the ballot paper, no modification amendment can be done. So this is all about ballot papers, and we are done with 107, 108, 109, 10. We are done with section 110. Bolo Jai Shri Ram. Are we clear till here? Are we clear till here? Are we clear till here? Clear. Great. Okay. So now there's one small section 111. So now there is one small section which is 111, which talks about circulations of members resolution. This is an average section. You can categorize it like category B. There's one section, section 111, 111, which talks about circulations of member resolution. So let's say meeting is going to be held and members want their resolution to be circulated. Then they can ask the company that company, we want this resolution also to be passed at the meeting. So if the shareholders want any new resolution to be passed at the meeting, can they request that? Yes, they can. So they can request the company to pass any resolution at the meeting. And also if they want any statement to be circulated to all the members, they can request the company that company, we want this statement to be circulated to all the members. Then they can request as per section 111. So according to section 111, members, these are the members, they can request the company to they can request the company to pass any resolution at the general meeting or to circulate any statement. So if they have any statement, they want it to be circulated to every member, they can request the company to circulate that statement to all the members. And if they want any resolution to be passed at the general meeting, they will make a request to the company. So members will request to the company. Minimum how many members will make request? Minimum those members who are required to call EOGM under section 100. So what is the requirement? In case of company having share capital, members holding at least 10% of paid up share capital, and in case of company not having share capital, members holding minimum 10% of TVP, 10% of total voting power, they can require any resolution to be passed at the general meeting, or they can require any statement to be circulated at the general meeting. So what basically they have to do, they have to prepare a written request. They want to any resolution to be moved at the general meeting now, so they have to request the company. How they will request? They have to prepare a written request, that is known as requisition, and they have to sign the requisition. That should be signed by all the requisitionists, and that should be submitted at the registered office of the company. So your requisitions should be signed by all the requisitionists, and it should be submitted at the registered office of the company. How many days before? If they want any resolution to be circulated at the meeting, then it should be submitted at least 6 weeks before the meeting. And if they want any statement to be circulated to all the members, then they should give the requisition at least 2 weeks before the meeting. So there is two separate deadlines. The deadline is 6 weeks before the meeting and 2 weeks before the meeting. If they are giving requisition for passing resolution at the meeting, then they will give requisition at least 6 weeks before the meeting. However, if they are giving requisition to circulate any statement to the members, they will give requisition at least 2 weeks before the meeting. And since they are asking any resolution or statement to be circulated to all the member, तो उसमें company का खर्चा आएगा. Yes, company have to incur expenses. Will company bear it? No. Company will ask for the reimbursement of their expenses from the members. ये जो लोग request कर रहे हैं, इनको ही खर्चा देना पड़ेगा. So all this members who are requesting a company to circulate a resolution, they also have to give the expenses. They also have to give estimated expenditure. जो भी होगा वो already उनको advance में deposit करना पड़ेगा. They also have to deposit the money to meet the expenses. There's one exception given that if हमने तो requisition time पे deposit किया था, but meeting early हो गई, meeting पहले हो गई, तो यहाँ पर माना जाएगा कोई default नहीं हुआ है. That is, if we deposited the requisition within this time limit, 6 weeks before the meeting, 2 weeks before the meeting. However, meeting was held earlier. Meeting was held within 6 months. In that case, within 6 weeks, in that case, it will still be valid. It will not be considered as invalid. Last point, if they are making any statement जो defamatory है, Defamatory means which is affecting somebody's reputation. So if these members are asking to circulate any statement which is defamatory, which is hampering anybody's reputation, in that case company or any person can apply to central government, and central government can pass order that this statement is defamatory, don't circulate this statement. So central government can order not to circulate that statement, and any cost incurred by the company will be borne by the requisitionist. So this is a very small section 111. 112 and 113 is already done. 112 talks about the authorized representative of governor or president, and 113 talks about the authorized representative of company. 114 is already done, which talks about ordinary resolution and special resolution. So only the two important sections are left, 115 and 117. 115 which talks about special notice, 116 is also done, and 117 is left. So two important sections are left. After that only minutes will be left. So the next section is special notice 115, which says that there are certain matters with respect to which special notice is required. कि अगर इन मैटर्स के रिस्पेक्ट में आपको रेजोल्यूशन पास करना है तो पहले कुछ मेंबर्स को स्पेशल नोटिस देना पड़ेगा कंपनी को. सो देयर आर 5 मैटर्स, लाइक 1 2 3 4 5. There are 5 matters with respect to which special notice is required to be given by members to the company in order to pass that resolution. मतलब अगर members चाहते हैं 1 2 3 4 5 इन 5 matters के रिस्पेक्ट में रेजोल्यूशन पास करवाने का, तो पहले मेंबर्स को स्पेशल नोटिस देना पड़ेगा कंपनी को. Are you getting this point? That in respect of these 5 matters, in order to pass resolution for these 5 matters, first members should give the special notice to the company before the meeting. So what if first I'll discuss the process of special notice, and after that I'll discuss the matters for which the special notice is required. So what minimum, how many members should give the special notice? Minimum members holding 1% of TVP, 1% of total voting power, or member holding 5 lakh paid up share capital. Minimum this much members should give the special notice. They will give special notice to the company. They can give special notice either individually or collectively. Individually मतलब सब अलग अलग, collectively मतलब सबके behalf में एक ही जन sign कर देगा. So they have to give special notice to company. When they will give special notice, they can give special notice maximum 3 months before the meeting, and minimum 14 days before the meeting they have to give special notice. So the special notice should be given maximum 3 months before the meeting and minimum 14 days before the meeting. So 3 months before the meeting to 14 days before the meeting, इस बीच वो लोग special notice दे सकते हैं. And when this members give special notice to the company, after that company has to forward this special notice to all the members at least 7 clear days before the meeting. Once a special notice is given, then the company has to forward that special notice to all the members at least 7 clear days. 7 clear days means excluding the date of meeting and date of notice. 7 clear days before the meeting, मतलब 7 clear days. तो 7 दिन पहले हमें ये फॉरवर्ड करना पड़ेगा सारे मेंबर्स को, और इस 7 दिन में हम सेंड करने वाला डेट और मीटिंग का डेट नहीं लेंगे. मतलब डेट ऑफ मीटिंग एंड डेट ऑफ नोटिस विल बी एक्सक्लूडेड. देयर शुड बी 7 clear days. And this forward we can forward this notice to all the members either individually or through advertisement in 2 newspapers, one in English, one in vernacular, having circulation in the state where the registered office of the company is situated. So this is a very small procedure of special notice which is given in section 115 that इतने लोगों को special notice देना है कंपनी को, and then company will forward this to all the members either individually, और if not possible to give individually, then we can make a newspaper advertisement. या तो अलग अलग सबको चिट्ठी भिजवा दो, अलग अलग देना पॉसिबल नहीं हो पा रहा है तो बस गांव में ढिंडोरा पिटवा दो, न्यूज़पेपर में एडवर्टाइजमेंट करवा दो. So this is the general process of special notice. After that we'll study for what matters special notice is required. Special notice is required for 5 matters. Number 1, to remove a director before expiry of his tenure. High Allah, section 169. Remember, we will study this in the director chapter tomorrow, section 169, that when you want to remove any director before expiry of his tenure, or you want to appoint a director in place of remove the director, you want to remove the director before expiry of his tenure, or you want to appoint somebody else in place of remove director. मतलब आप धक्के मार के निकालना चाह रहे हो, किसी को उसका टेन्योर खत्म नहीं हुआ है, टर्म खत्म नहीं हुआ है, फिर भी आप उसको निकाल रहे हो. So that is discussed in section 169. And for these two matters, for removing a director or before expiry of his tenure, or for appointing another director in place of the removed director, you have to pass special notice. Next, we studied in auditor chapter. Remember? If not, then you will get a flying charta from me. Auditor chapter we studied ना, that if you want that retiring auditor को reappoint नहीं करना है, हम नहीं चाहते रिटायरिंग ऑडिटर रिअपॉइंट हो, तो आपको स्पेशल नोटिस देना पड़ता है. रिमेंबर सेक्शन 140 सबसेक्शन 4. रिमेंबर सेक्शन 140 वी स्टडीड इन द ऑडिटर चैप्टर. हाँ बोल दो, मेरे जिगर को सुकून मिल जाएगा थोड़ा सा कि याद आ गया. ठीक है. So there we studied that if you want that retiring auditor should not be expressly reappointed, you want to expressly say that retiring auditor should not be reappointed, for that you have to pass special notice. And if you want somebody else in place of the retiring director, if you want to appoint somebody else in place of the retiring director, then also डायरेक्टर नहीं रे ऑडिटर, सॉरी मेरे मुंह से ना स्लिप ऑफ टंग हो जाता है. इफ यू वांट टू अपॉइंट समवन एल्स इन प्लेस ऑफ द रिटायरिंग ऑडिटर, सो ये दो पॉइंट ऑडिटर से रिलेटेड है, ये दो पॉइंट डायरेक्टर से रिलेटेड है. सो इफ यू वांट टू एक्सप्रेसली प्रोवाइड दैट रिटायरिंग ऑडिटर शुड नॉट बी रीअपॉइंटेड, और यू वांट टू if you want to expressly provide that the retiring auditor should not be reappointed, or you want to appoint any other auditor in place of the retiring auditor, then for these two matter also you have to give special notice. And lastly, for any other matter, if you prescribe in your article, in your AOA, you can prescribe any other matter for which special notice will be required. So these are the 5 matters for which special notice is required, and this is the process of special notice. और स्पेशल नोटिस में कुछ एडिशनल प्रोसीजर भी है जो इनके रिस्पेक्टिव सेक्शन में है. लाइक स्पेशल नोटिस का और एडिशनल प्रोसीजर हमने 140 में भी पढ़ा था, एंड सिमिलरली यू विल स्टडी अ सिमिलर प्रोसीजर ऑफ स्पेशल नोटिस इन सेक्शन 169 ऑल्सो. विद दिस वी आर डन विथ 115. 116 भी हमारा हो चुका है. वी आर ऑल्सो डन विथ 1116 विच वॉज टॉकिंग अबाउट द एडजर्न्ड मीटिंग. नाउ द नेक्स्ट सेक्शन इज 117. Now the next section is 117. This is a very small section, 2 मिनट में हो जाएगा. सेक्शन 117 बोलता है कि जब भी आप कोई रेजोल्यूशन पास करोगे तो आपको MGT 14 फाइल करना पड़ेगा 30 दिन के अंदर. रिमेंबर फेविकोल वी स्टडीड दैट व्हेनेवर वी हैव टू पास SR, फेविकोल, MGT 14 within 30 days. Remember that whenever we pass special resolution, we have to file MGT 14 to ROC within 30 days. Yes, madam, we remember. Where it is written? It is written in section 117. It is written in section 117 that whenever you will pass this resolution, a list is given that whenever you will pass this resolution, then you have to file MGT 14 to ROC within 30 days. So a list is prescribed that for this, for all this resolution, whenever you will pass this resolution, you have to file MGT 14 to ROC within 30 days. So here one point is given that company has to file MGT 14 to ROC along with a copy of explanatory statement within 30 days of the meeting. However, IFSC public company and IFSC private company is given extra deadline. They can file this MGT 14 within 60 days. For them, timeline is just double. Normal company is given 30 days. IFSC company is given 60 days. And we also have to attach a copy of resolution. Okay, so what are the resolution for which MGT 14 is required? Number 1, special resolution. Whenever you will pass special resolution, then MGT 14 has to be filed in form number. MGT 14 has to be filed within 30 days to ROC. Next, you know what? If there is any matter for which unanimous resolution of member is required. Unanimous resolution of member means if there is any matter for which the approval of all the members is required, then that resolution you have to file to the ROC in the form number MGT 14. So let's say entrenchment provision. You remember now that if you have to put the entrenchment provision in case of a private company, then you have to take unanimous approval of the members. You have to take approval of all the members. So that resolution have to be filed to ROC in the form number MGT 14. Next, you have studied that whenever you will pass BR for the appointment, reappointment, renewal or change in terms and conditions of MD. So for appointing a managing director, you have to pass a BR, and when you will pass that board resolution for appointment, reappointment of MD, that board resolution also have to be filed to the ROC within 30 days in the form number MGT14. So MGT14 सिर्फ SR का नहीं है, MGT14 इन सब का है, जगत का है. MGT14 सिर्फ SR का नहीं है. So MGT14 is required not only in the case of SR but in all these cases. So if any BR is passed for appointment, reappointment of MD, then also MGT14 is required. If any resolution is passed by a class of members, sometimes we know na, sometimes we do only class meeting of only class of members. Then if any resolution is passed by only a class of member, then that class resolution should also be filed to the ROC within 30 days in MGT14. Next, if we are passing resolution for the voluntary winding up under section 304, you have studied about voluntary winding up in your SBEC part C, right? So if you pass resolution for voluntary winding up of the company, that resolution also have to be filed to the ROC within 30 days in the form number MGT14. Next is section 179 subsection 3, which we will study in day after tomorrow. Section 179 subsection 3 says that there are certain matters for which BR can be passed only at BM. In section 79, you will study that there are certain matters with respect to which board resolution can be passed only at the board meeting. Only at the board meeting. So, for all those matters where you pass BR at the BM, where you pass BR at BM, BR at BM means board resolution at board meeting. So if you are passing board resolution at board meeting, that board resolution also have to be filed to ROC within 30 days in the form MGT14. However, there is one exception, that there was one point that if you want to make loan, guarantee, security, investment, for that also you have to pass BR at BM. But for banking company, for NBFCs, for housing finance, ये तो उनका daily का काम है. This is the ordinary course of business for them. They will daily give loan, so daily they will take board approval, daily they will call board meeting. The answer is no. So this BR at BM is not required for banking companies, housing finance, HFCs. Why? Because loan guarantee security is their daily activity. सो नॉर्मली नॉर्मल कंपनी को लोन गारंटी सिक्योरिटी देने के लिए बोर्ड रेजोल्यूशन पास करना पड़ता है और उस बोर्ड रेजोल्यूशन को MGT14 में फाइल करना पड़ता है. बट एक्सेप्शन है कि एक बैंकिंग कंपनी NBFC HFC को ये करने की जरूरत नहीं है, क्योंकि उसका तो डेली का काम है, उसका ऑर्डिनरी कोर्स ऑफ काम है, उसका ऑर्डिनरी कोर्स ऑफ बिजनेस है, तो हमने उसको एग्जेम्प्ट कर दिया. सो नॉर्मल कंपनी हैज टू फाइल दिस BR in case of loan guarantee security investment, but a banking company, NBFC housing finance, if it is passing a BR for giving a loan guarantee security, then it is not required to file MGT14 within 30 days. And you know what, these resolutions, these board resolutions which are passed at board meeting, these are very confidential. These are very confidential, and it is never open for inspection for anybody except directors. Only directors can see that. Apart from directors, nobody can inspect these documents. Just like books of account. Remember when we studied books of accounts, section 128, books of accounts, there we studied that books of accounts can be inspected only by director and by no other person. Similarly, this resolutions BR which you pass at BM, these are very confidential document. This can not be open for inspection by member. This BR can be inspected only by directors, and this is not open for inspection because these are confidential document. Lastly, any other resolution which is prescribed by the government and which is available in the public domain, even for that resolution also company can be asked to file MGT14 within 30 days. So central government can prescribe any other resolution for which companies are required to submit MGT14. So here we are studying that matters for which MGT14 is required, matters for which a company has to file MGT14 within 30 days. With this, we are done with section 117. Congratulations. You know what, section 118 and 119 is with respect to minutes. इस पेंसिल को क्या हो रहा है आज, सब कुछ भसक रहा है. ओके, सेक्शन 118 एंड 119 इज विथ रिस्पेक्ट टू मिनट। जो मैं आज नहीं पढ़ा रही हूँ इसका ना मैं एक छोटा सा 10-15 मिनट का वीडियो बना के डाल दूंगी, कभी खाना खाते हुए देख लेना। सो सेक्शन 118 119 मिनट्स का है। आई विल अपलोड अ स्मॉल वेरी शॉर्ट वीडियो, प्यारा सा नन्ना मुन्ना सा 10-15 मिनट का वीडियो बना दूंगी, एंड दैट आई विल अपलोड, दैट यू कैन रिवाइज फ्रॉम दैट स्मॉल 10 minutes video even while having your snacks or breakfast. So section 118 and 119 is with respect to minutes. We are done with all the other section till 117 and 120 is not very important. section 120 बकवास सा सेक्शन है जो ये बोलता है कि आप अपने डॉक्यूमेंट्स जितने भी हैं वो फिजिकल फॉर्म में भी मेंटेन कर सकते हैं, इलेक्ट्रॉनिक फॉर्म में भी मेंटेन कर सकते हैं. सो दिस इज नॉट वेरी इंपॉर्टेंट. 120 नॉट गिवन इन योर बुक ऑल्सो. हियर इट अ सिंपल पॉइंट इज गिवन that all the documents can be prepared by the company even physically also or electronically also. And 122 is also a small section. अच्छा 117 का पनिशमेंट भी दिया है, खैर पनिशमेंट देख लेना. एक और सेक्शन था, रुको 122. हाँ, here come to page number 844. Come to page number 844. There is a small section report on AGM. एक छोटा सा सेक्शन है 122 जो सिर्फ लिस्टेड कंपनीज के लिए है, सिर्फ लिस्टेड पब्लिक कंपनीज के लिए है. There is a small section, the last section of this chapter 122. यहाँ आपका खत्म हो जाएगा ना, जनरल मीटिंग वाला चैप्टर 122 में खत्म हो जाएगा. याद करो अपना जो डिविडेंड चालू होता है वो 123 से चालू होता है, 123 से 127 तक डिविडेंड चलता है. देन 128 से अकाउंट्स वाला चैप्टर चालू होता है 138 तक, फिर 139 से ऑडिटर चालू होता है 148 तक. सो ये जो 122 है 88 to 122. सो दिस 122 इज द लास्ट section of general meeting. 122 is the last section of your general meeting chapter जो ये बोलता है that all the listed public company have to give a report on AGM. Small sweet section 122, last section of general meeting chapter, which says that every listed public company have to prepare a report on the AGM in the form number MGT 15. Every listed public company have to prepare a report on the AGM and that report has to be in the form number MGT 15, and that MGT 15 they have to submit to the ROC within 30 days of the AGM. That's it, done. That MGT 17 they have to submit to the ROC within 30 days of the AGM. तो यहाँ complete होता है हमारा ये बहुत प्यारा chapter. With this we are done with this chapter. With this we are done with this chapter. आप सोच रहे होंगे मैम 121 क्या है. सो एक बार हम सेक्शंस रिवाइज कर लेते हैं इस चैप्टर. वैसे तो वी आर डन विद दिस चैप्टर. लेट्स जस्ट revise the sections of this chapter in 2 minutes. Section 96 was for AGM. 96 AGM, 100 EOGM, 100 EOGM. After that दो सेक्शन एक जैसे थे 97 98. 97 was for AGM by NCLT, 98 was for EOGM by NCLT and 99 was punishment. तो ये 5 सेक्शन अपन ने एक साथ याद किए थे. After that we studied 101 शगुन का लिफाफा नोटिस 101. 102 talks about explanatory statement, ordinary business and special business. 103 quorum, 104 chairman, 105 proxy. यहां तक पढ़े? हाँ मैडम. उसके बाद 106 पढ़े restriction on voting right only in 2 cases, calls in arrears and lien. उसके बाद we studied 107 8 9 10 together, 4 methods of voting. 4 methods of voting, 107 8 9 10. 107 show of hand, 108 e-voting, 109 poll and 110 postal ballot. इतना हो गया. Yes. After that we studied 111 which is circulation of members resolution. We just studied 11 12 and 13 was for appointment of representative in case of president or governor or any body corporate. 114 कुछ नहीं, OR ऐसा define करता है ordinary resolution, special resolution. 115 we just studied special notice. 117 we just studied MGT 14 वाला section. MGT 14. 1116 was a small section adjourned meeting को लेके. 1118 and 1119 is with respect to minutes. 120 is a small section जो ये बोलता है इलेक्ट्रॉनिक फॉर्म में मेंटेन कर सकते हैं. 121 is a small section which says that all this provision of general meeting is not applicable to OPC. Why? Because OPC is not required to hold AGM. OPC is not required to hold AGM. That is why all this chapter, all this section 96 to 120 is not applicable to OPC. Why? Because OPC is एक अकेला बंदा अपने आप से मीटिंग नहीं कर सकता. That is why OPC is exempted from all this provision. And how can a resolution in case of OPC be passed? छोटी सी बात है, वैसे आपके मॉड्यूल में है नहीं. In case of OPC, if single member approve anything and prepare the minutes, enter that matter in the minutes, then the resolution will be deemed to be passed for the OPC. Meeting करने की जरूरत नहीं है. No need to hold meeting for OPC. And 122 we just studied, which is report of AGM, which is report of AGM only for listed public companies. So with this we are done with all the sections of this chapter. Form, there is only 5 forms we studied: MGT 11, 12, 13, 14 and 15. MGT 11 is for the proxy form. MGT 12 is for the polling paper. MGT 13 is for the polling report or polling result, we can say report. MGT 14, ये तो आपको अपन को पता है, section 117 में पढ़े. All this resolution have to be submitted in MGT 14 to ROC. And MGT 15 we just studied under section 122 that all the listed public company have to prepare a report of general meeting in the form number MGT 15. ठीक है, तो इसी के साथ we have revised all the forms of this chapter, all the sections of this chapter, all the every provision of this chapter. Trust me, इतना कवरेज आपको कहीं भी नहीं मिलेगा, मैं ये डंके की चोट पे बोल सकती हूँ. और अगर आप इतना पढ़ लेते हो ना, फिर तो आप कर लोगे. अब बस आंसर राइटिंग प्रैक्टिस थोड़ी सी कर लेना, क्वेश्चंस पास्ट एग्जाम क्वेश्चन वगैरह देख लेना, आंसर राइटिंग आंसर लिखते कैसे वो देख लेना. कंसेप्ट रिवाइज करने के लिए दिस इज मोर देन इनफ. आंसर राइटिंग प्रैक्टिस कर लेना, पास्ट एग्जाम क्वेश्चन देख लेना. दिसंबर 2021 का क्वेश्चन देख ही लेना. दिसंबर का क्वेश्चन प्लीज सी द दिसंबर क्वेश्चंस एंड आंसर ICSI सजेस्टेड आंसर देख लेना. ठीक है, so with this we are done with this. I'll make a short video on minutes, that is 118 and 119, and we are completely done with the general meeting chapter. Tomorrow we will start with the director. Section 149. So tomorrow we will, हम लोग section wise पढ़ेंगे. मॉड्यूल में ऊपर नीचे होगा, मेरे को मत बोलना, मैं पहले बता दे रही हूँ, हम लोग section wise पढ़ेंगे. Tomorrow we will study section 149 to section 172. Section 149 to section 172. That is appointment and qualification of director. With this, we are ending our today's session. I hope आपको समझ में आ रहा है जो मैं पढ़ाना चाह रही हूँ. If anybody of you have any doubt, then please do let me know. I have 2 doubts pending. I remember I'll make a video on that. But do remember that anybody of you have any doubt, you can let me know over Telegram, Instagram, anywhere. I'll surely try to clear your doubt. It might take 1 day, 2 day, 3 day, but I'll surely clear your doubts at the earliest. And with this, we are ending our today's session. I'll see you tomorrow at 12 p.m. on the SBC revision on the Yash's channel. So see you tomorrow. Till then, keep learning, because the more you learn, the more you grow, and the more you grow, the more you achieve. Take care. Bye bye.